Welcome to the deep dive.
Yeah.
Today, we're really getting into the bedrock of criminal law.
Yeah, the absolute fundamentals.
Think of this as your, well, essential guide to the core ideas shaping the whole system. We've got some great source materials here.
Legal theory excerpts mainly, focusing on those building blocks.
Right. And our mission, really, is to unpack these ideas, make them clear, maybe even shed some surprising light on them.
Definitely. Criminal law can seem, super complex, like a tangled web.
You can.
But it's actually built on, well, a fairly small number of key concepts. We want to illuminate those things, like burden of proof, why we punish people, what actually makes something a crime.
Exactly. So instead of you having to wade through dense legal texts, we're doing a focused exploration. A deep dive, if you will.
Getting you straight to the crucial bits.
Okay, let's kick things off. We're better to start than the burden of proof. Absolutely central.
Couldn't agree more. So when someone's accused of a crime, they walk into court with this major protection, the presumption of innocence.
Innocent until proven guilty. We hear it all the time.
And it's not just a phrase. It means the prosecution, the state, carries the entire burden of proof. They have to prove everything.
And that burden, it's not easy to meet, is it? The standard is really high.
Extremely high. It's beyond a reasonable doubt.
What does that actually mean in practice?
It's the highest standard we have in law. Period. It means the evidence has to be so compelling, so convincing, that there's no other logical explanation for the facts except that the defendant did it.
Wow. Much higher than in civil cases, right?
Oh, miles higher. Civil cases often use preponderance of the evidence, which is basically just more likely than not. This beyond a reasonable doubt standard shows how seriously we take criminal charges.
It really underscores the potential consequences.
Exactly. Though it's interesting, what is a reasonable doubt? That can still be a bit subjective, which leads to a lot of legal discussion.
Now, something else in our sources that caught my eye was jury nullification. You don't hear about that on TV dramas much.
No, you really don't. It's a fascinating, maybe even controversial idea.
So what is it?
It's basically the power a jury has to say not guilty, even if they think, technically, the defendant broke the law.
Really? They can just disregard the law?
If they fundamentally disagree with the law itself, or if they feel applying it in this specific case would be deeply unfair. Yeah.
That sounds significant. A real check on the system.
It is. And here's the kicker. Judges almost never tell juries they have this power.
Oh, why not?
Well, it's complicated, but it's often seen as this sort of ultimate safety valve.
Yeah.
A way for the community through the jury to push back on what the legislature has decided should be criminal.
Like a hidden power. Okay, let's move on. Say there is a guilty verdict, then comes sentencing. The sources mentioned determinate sentencing.
Right. So in a determinate system, the law lays out a specific range of punishment for a crime, like, say, 5 to 10 years.
Right.
And the judge has to pick a sentence within that range. They can't just pick any number.
What influences where they land in that range?
Key factors are, well, obviously the seriousness of the crime itself, but also, very importantly, the defendant's prior criminal record.
Ah, so past offenses matter.
Big time. Someone with a history of similar crimes is probably going to get a sentence toward the higher end of that range.
Got it. That makes sense. A structured approach. Okay, now let's shift gears a bit and ask the big why. Why do we punish people at all? Our sources break down different theories. Let's start with retribution.
Retribution. At its heart, it's the idea that punishment is deserved. It's the morally right response to someone committing a crime.
Kind of like just desserts.
Exactly. The focus is on the wrongdoing itself. It's based on the idea that people deserve to be punished because of their actions. And a key part of it is that we shouldn't just use people as a means to an end, like only punishing someone to scare others.
The punishment is the point.
Precisely. It's seen as the just outcome for the wrongful act.
The materials also split retribution into choice-based and harm-based. What's the difference there?
Good question. Choice-based retribution really zeroes in on the voluntary decision to commit the crime. The punishment is tied to that free choice.
Okay.
Harm-based, on the other hand, looks more at the harm caused by the act, even if the person's ability to make a fully conscious choice was, say, impaired. Think maybe someone with severe schizophrenia.
So harm-based might still punish even if the choice wasn't entirely free.
Potentially, yes. The focus shifts to the negative consequences, the harm done, regardless of the level of blameworthy intent in the traditional sense. It raises some really complex ethical questions.
Definitely. Okay, so that's retribution. The other major theory is utilitarianism. How's that different?
Utilitarianism takes a completely different angle. It's not about what the offender deserves. It's about what's best for society as a whole.
The greatest good for the greatest number, that sort of thing.
That's the core idea. Punishment is justified if it leads to better overall consequences for everyone. It's forward-looking.
And our sources list several ways utilitarianism aims to achieve this through punishment, right?
Yes, quite a few. There's general deterrence.
Scaring off the general public.
Yep. Making an example. Then specific deterrence, which is about stopping that particular offender from doing it again.
Makes sense.
Then you have incapacitation, basically locking someone up so they physically can't commit more crimes while they're confined.
Right. Prison.
Rehabilitation is another, trying to fix the underlying issues through treatment or education so they won't reoffend.
More about changing the person.
Exactly. And then there's restorative justice, which is a bit different. It focuses more on the victim, repairing the harm, and trying to reintegrate the offender.
Bringing things back into balance, maybe?
Kind of. And finally, the sources mention critical theories, which look at how things like power, race, and class play into who gets punished and why. They question the whole system sometimes.
Wow, that's a lot of different angles on why we punish. Okay, shifting again, let's talk about understanding the laws themselves. Statutory interpretation. Why is this so important?
Because laws aren't always crystal clear. Language can be ambiguous, right?
Sure.
Lawmakers try, but they can't possibly think of every single scenario. So statutory interpretation is how courts figure out what a law actually means and how it applies to a specific situation.
And the first step is usually looking at the plain meaning.
Almost always. Courts start with the words themselves. Are there definitions in the statute? What's the grammar doing? Punctuation. You try to get the ordinary sense of the text.
The sources also mention these interesting rules of construction. Can you give an example?
Sure. There's a Latin one, expressio nuntius est exclusio alterius.
Okay, what's that?
It basically means if a law lists specific things, it implies that things not on the list are intentionally left out.
Ah, so if a sign says no dogs or cats, it probably doesn't mean no goldfish.
Exactly. Another one is a justum generis. If you have a list of specific things followed by a general term, like dogs, cats, hamsters, and other animals, that other animals usually means other similar domestic pets, not, say, lions or bears.
Right, keep it in the same category.
And there's the common sense rule of avoidance of absurdity. Courts try not to interpret laws in ways that lead to completely ridiculous results. They'll even look at titles and headings in the law for clues.
It's all about figuring out what the lawmakers intended then.
That's a huge part of it, which leads to looking at legislative intent and history.
Going beyond the words.
Sometimes, yeah. What was the overall goal? Were they trying to deter something specific? Protect the public? Courts might look at committee reports, debate transcripts, earlier drafts, anything that sheds light on the purpose behind the law.
And what about past court decisions? Precedent.
Hugely important. If a higher court has already interpreted a part of a law, lower courts in that jurisdiction generally have to follow that interpretation. That's binding precedent.
Creates consistency.
Exactly. It brings predictability to how the law is applied over time.
But laws can't just do anything. There are constitutional limits, right?
Absolutely fundamental. No law can violate constitutional rights. Things like due process, free speech, protection against double jeopardy.
Being tried twice for the same crime after you've been acquitted or convicted.
Right. And you also can't have ex post facto laws. You can't apply a new criminal law or a new interpretation backwards in time to punish someone for something that wasn't illegal or wasn't interpreted that way when they did it.
That seems fair. Now, what if a law is still confusing after all that? The rule of lenity.
Yes. This is kind of a tie goes to the defendant rule. If a criminal law is still genuinely ambiguous after using all the other interpretation tools, the court should interpret it in the way that's most favorable to the defendant.
Why is that?
The idea is fairness. People should have clear notice of what conduct is actually criminal. If the law is truly vague, you lean towards not punishing.
Okay. And what about laws that just go too far? Unconstitutional laws.
Right. Sometimes laws clash directly with the Constitution. Our sources talk about strict scrutiny.
That sounds intense.
It is. It's a very high bar the government has to clear if a law infringes on fundamental rights. The law must serve a compelling state interest, something really, really important, and it must be the less restrictive alternative.
What do you mean?
Meaning if there's another way to achieve that important goal that doesn't restrict rights as much, the government has to use that less restrictive way.
Got it. The sources also mention bills of attainder. What are those?
Those are laws passed by a legislature that basically declare a specific person or group guilty of a crime and punish them, all without a trial.
That sounds incredibly unfair.
It is, and totally unconstitutional. The Constitution explicitly forbids them. It violates the whole idea of separation of powers and the right to a fair trial.
And finally, under unconstitutional laws, vague criminal laws.
Yes. A law can be unconstitutional just because it's too vague, if it doesn't clearly define what conduct is forbidden.
People don't know what they can or can't do.
Exactly. That's one problem, lack of fair notice. The other big problem is it gives too much power to police and prosecutors. They can enforce it arbitrarily or maybe even discriminatorily if the lines aren't clear. A law has to be clear enough for an ordinary person to understand what's illegal.
Okay, that makes sense. We've covered interpreting laws. Now let's get into the actual elements of a crime, starting with actus reus, the criminal act.
Right. Generally, you need a voluntary act. Just thinking bad thoughts isn't a crime. There has to be some kind of physical action or sometimes a failure to act.
What counts as voluntary? Seems obvious, but I bet there are nuances.
There are. A voluntary act is basically a willed bodily movement, pulling a trigger, punching someone, signing a false document.
Okay.
But yeah, nuances. Habitual acts, things you do almost automatically, usually still considered voluntary.
Like driving a familiar route.
Kind of, but truly unconscious acts, like something done while having a seizure or maybe sleepwalking, those are generally not voluntary. Though, interestingly, the law in many places treats sleepwalking and acts under hypnosis as voluntary, which is debated.
What about acting under duress? Like if someone forces you?
Technically, the act itself is still voluntary. You chose to do it, even under threat. But duress can be a separate defense to the crime.
Ah, okay. And reflexes?
Not voluntary, like flinching away from a bee sting and knocking something over. Also, just being in a certain status, like being addicted to drugs, isn't an act itself. And if someone physically moves you somewhere against your will, you haven't committed a voluntary act just by being there.
What about this idea of culpable negligence mentioned in the sources? Acting when you know you have a condition that might cause harm.
Yeah, that's about liability for consequences. Say you know you have a seizure disorder that can cause blackouts, but you decide to drive anyway, and you cause a crash during a blackout. The act of driving was voluntary. The negligence was driving knowing the risk. That negligence can form the basis for criminal liability for the harm caused.
Okay. Now, what about not acting? Omissions. When can failing to do something be a crime?
The general rule is you don't have a criminal duty to help someone, even if they're in serious danger. The law doesn't usually force you to be a good Samaritan.
But there are exceptions.
Yes, definitely. Criminal liability for an omission only arises if there's a specific special duty to act.
And where do these duties come from?
Several places. Certain status relationships, like parents having a duty to care for their young children, or sometimes spouses for each other.
Okay.
Contractual obligations, think of an on-duty lifeguard who fails to attempt a rescue.
Right.
Statutes can impose duties, like on police officers. And importantly, your own prior actions can create a duty. If you accidentally create a dangerous situation, you generally have a duty to try and fix it or warn others. Or if you voluntarily start helping someone who's in danger, you usually can't just abandon them recklessly if it leaves them worse off.
Interesting.
There can also be duties to control others, like parents controlling their kids, sometimes employers, their employees, and duties related to property you own or control.
So it's not a blanket duty, but specific circumstances trigger it.
Exactly. Limited but important exceptions.
One last bit on actus reus. Possession. How is just having something an act?
Legally, possession itself can be the criminal act, but it generally requires knowledge. You have to know you possess the item.
Two types, right? Actual and constructive.
Yes, actual possession is direct physical controlled drugs in your pocket, a weapon in your hand.
Got it.
Constructive possession is a bit trickier. You don't have it on you, but you have the power and the intent to control it. Think drugs hidden in your car's trunk or in a safe deposit box you have the key to. Even items in a house you control can count.
And does it matter how long you possess it?
Generally, no. Even very brief possession can be enough to satisfy the actus reus for a possession crime.
Okay, so we have the act. Now the mental part, mens rea, the criminal mind.
Right. Most crimes require not just an act, but also a certain mental state when doing the act. What was the defendant thinking? What did they intend?
But not all crimes.
Not all. There are exceptions called strict liability offenses, often regulatory things like selling contaminated food. For those, you can be guilty just by doing the act, even if you didn't intend harm or know it was contaminated. But for most traditional crimes, mens rea is crucial.
Our sources mention both common law and model penal code, MPC, ways of describing these mental states. Common law first.
Common law often uses broader categories. Specific intent usually means you acted with a particular purpose in mind or knew a result was practically certain. Think burglary, intending to commit a felony inside. General intent is usually less specific, often covering recklessness or negligence. Just intending the physical act itself, without necessarily intending the ultimate consequence. Think battery, intending to make offensive contact. And then, as we said, strict liability needs no mental state.
And the model penal code. It seems more structured.
It is. The MPC tries to be more precise. It lays out 4 main levels of culpability. Purposely is the highest. It was your conscious goal to cause the result.
Like aiming and firing a gun to kill someone.
Exactly. Then, knowingly, you were aware that your conduct was practically certain to cause the result, even if it wasn't your specific goal.
Like setting off a bomb in a building knowing people are inside, even if your goal was just to destroy the building.
Right. Next is recklessness. This means you consciously disregarded a substantial and unjustifiable risk that your conduct would cause harm. You knew there was a big risk, but you did it anyway. It's a gross deviation from how a reasonable person would act.
Like drug driving at high speed.
Classic example. And finally, negligence, sometimes called gross negligence. Here, you should have been aware of a substantial and unjustifiable risk, even if you weren't consciously aware of it. Again, a gross deviation from reasonable care.
Like maybe forgetting to check if a safety mechanism was engaged before doing something dangerous?
Something like that, if the failure to check was a major lapse. The MPC also clarifies that conditional intent counts, like intending to shoot someone if they step onto your property still counts as purposeful. And if you prove a higher mental state, like purposely, you've automatically satisfied the lower ones, like knowingly or recklessly.
What if a law doesn't say what mens rea is needed?
Good question. The MPC has default rules. If a statute is silent, the MPC usually requires proof of at least recklessness for every element of the crime.
So no accidental convictions unless it's at least reckless.
Generally, yes, under the MPC approach. And if a statute mentions a mental state for just one part of the crime, that state is presumed to apply to all the other parts too, unless it says otherwise. The MPC really pushes back against strict liability in serious crimes. It wants at least negligence if nothing else is specified.
Okay. What about this idea of willful blindness?
Ah, yes. Sometimes called deliberate ignorance. It's basically when someone strongly suspects something illegal is happening, but they intentionally avoid finding out for sure because they want to be able to say, I didn't know.
Sticking your head in the sand.
Pretty much. The law often treats that deliberate avoidance of knowledge as equivalent to actual knowledge. If you were aware of a high probability that something was true, and you consciously avoided confirming it, you might be held legally responsible as if you knew it all along, unless you genuinely believed it wasn't true.
Interesting. And quickly, how can jury instructions about mens rea mess things up?
Well, if the judge tells the jury the wrong mental state is required, it can lead to problems. If they instruct on a lower state than needed, say negligence when recklessness is required, but the jury finds that lower state, it might be okay, harmless error.
But if they instruct on a higher state than needed,
That's usually an erroneous error. If the jury convicts based on meeting that higher state, the conviction might get overturned because maybe they only really believed the defendant met the actual lower standard required by the law.
okay, complex stuff. Let's move to mistake. Can being wrong about something be an excuse?
Sometimes. It depends. Big difference between being mistaken about a fact versus being mistaken about the law. And it also depends on the mens rea required for the crime.
Let's start with mistake of fact. How does common law handle that?
Common law often asks if the mistake was reasonable or unreasonable. For general intent crimes, an unreasonable mistake usually isn't a defense, but a reasonable one often is. For specific intent crimes, even an unreasonable mistake might be a defense if it means you didn't have that specific intent.
Like if you unreasonably thought something belonged to you when taking it, that might negate the intent to steal.
Possibly, for a specific intent crime, like larceny. The MPC simplifies this a bit.
How so?
The MPC just asks, does the mistake, reasonable or not, prevent the defendant from having the specific mental state required by that crime? So, an unreasonable mistake won't help if the crime only requires negligence or recklessness. But it could be a defense if the crime requires purpose or knowledge. A reasonable mistake is generally a defense under the MPC for any level of culpability.
Okay. Now, mistake of law. The old saying is, ignorance of the law is no excuse.
True.
Mostly true. That's the general rule. You're expected to know the law. But like always, there are a few narrow exceptions.
Such as?
Well, if you relied on a statute that was later struck down as unconstitutional, or if you relied on a court decision interpreting a law, and that decision was later overturned, your actions between the decision and the overruling might be excused.
What about relying on advice from, say, a government official? That's the trickiest one. Generally, just getting bad advice from a random official isn't enough. But if you relied on an official interpretation from the agency or person actually responsible for enforcing or interpreting that specific law, think like a formal opinion from the Attorney General that might work as a defense. It's a high bar, though.
Okay, we're almost there. Final piece. Causation, connecting the act to the harm.
Right. Two parts here. First is actual cause or but-for cause.
Meaning, but for the defendant's act, the harm wouldn't have happened.
Exactly. Would the result have occurred when and how it did without the defendant's action or culpable omission? If the answer is no, you have actual cause. Even speeding up someone's death counts. If your action was necessary for the death to happen as it did, that's actual cause.
Okay, but that's not enough on its own, is it? There's proximate cause.
Correct. Proximate cause or legal cause is about fairness and foreseeability. Was there some crazy intervening event between the defendant's act and the harm that was so bizarre or abnormal that we shouldn't hold the defendant responsible anymore?
Like if you injure someone and then the ambulance crashes on the way to the hospital due to unrelated negligence by the driver.
That's the kind of scenario where proximate cause questions arise. Was the intervening cause the ambulance crash too remote or unforeseeable? The common law often asks if the intervening cause was too abnormal. The MPC asks if the result was not too remote or accidental, given the defendant's conduct. It's about drawing a line somewhere.
Wow. Okay. We have really covered a huge amount of ground here. Burden of proof, punishment theories, interpreting laws, the act, the mental state, mistakes, causation.
Yeah, it's the whole framework, really. Understanding these building blocks, the presumption of innocence, the different reasons we punish, how laws are read, actus reus, mens rea, mistake, causation. It gives you such a valuable lens for looking at the justice system.
And the nuances are incredible, aren't they? The different levels of intent, the exceptions for mistake of law. It shows how complex trying to achieve justice really is.
Absolutely. It's not simple math. It's about applying these principles to messy human situations. We hope this deep dive has helped make those principles a bit clearer for you.
Definitely. So as we wrap up, here's something for you, the listener, to think about. Given all those theories of punishment, retribution, deterrence, rehabilitation, restoration, which one or maybe which combination makes the most sense to you for dealing with crime today? Why? Or maybe think about mens rea. How could a misunderstanding of whether someone acted purposely versus recklessly totally change the outcome of a real case? Lots to chew on there.
For sure.
Thanks for joining us on The Deep Dive.
Welcome to the deep dive. Today, we're getting into some really critical legal ground.
We are.
We're looking at how the law defines and, importantly, distinguishes between different ways people can harm each other.
Yeah.
You know, everything from homicide charges right down to things like assault and battery.
Right. It's a whole spectrum.
Exactly. And we've looked over a bunch of legal definitions and distinctions for this. Our mission really is to kind of pull out the core elements, try and clarify the tricky nuances, and just give you a clearer picture of these legal ideas.
Absolutely. And it's fascinating how the system tries to parse these situations, looking at state of mind, the actual events.
Yeah.
Getting these details right really shows how seriously the law takes it all.
Okay, let's dive right in then. Deliberate homicide. Maybe start with common law premeditated murder. When we hear premeditated, I think most people think like detailed planning sessions.
Yeah, but it's a bit more nuanced than that, legally speaking. It's more about the quality and quantity of thought. What most places look for is what they call a brief reflection. The idea is the killer has to have actually thought about the act beforehand, even just for a moment.
Ah, so not necessarily days of plotting, just a conscious thought before acting.
Precisely. And proving that That quality of thought, that can be really challenging in court,
Yeah.
leads to complex arguments.
I bet. So it's that conscious decision that separates it from something purely impulsive.
Exactly. And there's this related idea of acting with cool purpose.
Cool purpose.
Yeah, meaning acting without intense passion or excitement. A more detached decision, even if it happened pretty quickly.
Okay. And prosecutors trying to prove this premeditation, they look for specific signs, right? Earmarks, the sources call them.
Right. Things like planning activity. Did they do anything beforehand to set it up?
Like buying a weapon or something.
Exactly. Or motive. Did they have a reason, thought out beforehand? And then the manner of killing itself can be revealing. Well, the example used in our sources, shooting someone in the forehead, that suggests a very deliberate, targeted act, doesn't it?
Yeah, definitely. More than, say, a wild struggle.
Right. It points towards a certain level of intentionality.
Makes sense. Okay, so how does common law deliberate murder differ from premeditated murder then? Or are they the same?
Closely related, but deliberate murder is often defined as the unlawful killing of another person with malice aforethought.
Malice aforethought, that sounds very legalese.
It is a bit. It's kind of a shorthand. It covers both the explicit intent to kill that's express malice and also an implied form.
Implied malice? Like what?
Well, that ties into the idea of intent to inflict grievous bodily injury.
Okay, so maybe you didn't specifically intend for them to die, but you intended to hurt them really badly.
Exactly. Or acting with such reckless indifference to a really high risk to human life that death results. Even without the explicit goal of killing, the actions show such a disregard for life that the law might treat it as equivalent to deliberate murder.
So it's like understanding the severe risk, the potential for death, and just doing it anyway.
You got it. And it's worth noting, our sources mention that things like being voluntarily intoxicated or having certain mental defects generally don't get you off the hook for that required intent.
Right. Though that raises some tricky questions about impairment and culpability, I imagine.
Oh, absolutely. Drawing those lines is tough.
Okay, let's shift gears a bit. Voluntary manslaughter. This feels different, more focused on emotion, right? The whole sudden heat of passion idea.
That's the key concept at common law, yes. If a killing happens in this sudden heat of passion, and it's triggered by what the law considers adequate provocation, it can actually reduce a murder charge down to voluntary manslaughter.
So the idea is that the provocation was so intense it clouded their judgment. Less culpable.
That's the rationale.
Yeah.
But there are very specific requirements, 4 key elements actually.
Okay, what are they?
First, the killer has to have actually been provoked. That's subjective. Were they upset? Second, the provocation has to be something that would make a reasonable, ordinary person lose control. That's the objective test.
Okay, subjective feeling, objective trigger. What else?
Third, the killer must not have had time to cool off between the provocation and the killing. Again, that's subjective. Did they cool down?
And the fourth must be the objective version of that.
Exactly. A reasonable person in that situation wouldn't have cooled off either. So it's this mix of what the defendant actually felt and did versus what society expects of a reasonable person under those circumstances.
So there's like a societal benchmark for what counts as provocation and how long you reasonably stay hot.
Precisely. And common law is pretty rigid about what counts as adequate provocation. It uses a strict categorical approach, almost like a checklist.
Okay, what's on the list? I think our sources mentioned witnessing spousal adultery.
Yeah, that's a classic one.
Seeing a violent attack on your immediate family.
Right.
Being violently attacked yourself. Engaging in mutual combat, is that it?
Those are the main ones often cited. Sometimes being the victim of an unlawful arrest is included too. It's quite specific.
Yeah, very specific. What if something else happens that's incredibly provocative but isn't on that list?
That's the limitation of the strict common law approach. It raises questions.
And there's the mere words rule too. That seems important.
Very important. Generally, at common law, just words alone, no matter how insulting or awful, usually aren't enough provocation to knock murder down to manslaughter.
So someone yelling insults at you isn't usually enough.
Typically not. However, some places recognize an exception for what are called informational words.
Informational words.
Yeah, like words that suddenly convey shocking, devastating news. Maybe someone blurting out they committed some terrible act against your family. The idea is the information itself can be as provoking as a physical blow.
Wow, okay. So the content, not just the insult. That's fascinating. Okay, let's keep moving down the scale. Involuntary manslaughter and depraved heart murder. Where do these fit?
Okay, so involuntary manslaughter usually involves a death that results from, at minimum, criminal or gross negligence.
Meaning you didn't intend death, but you acted really carelessly, like way beyond ordinary carelessness.
Exactly. A significant disregard for others' safety. Now, depraved heart murder, that's a step up in culpability, closer to intentional killing, but without the specific intent to kill.
How does that work?
It's about showing an extreme indifference to the value of human life, acting so recklessly with such a lack of concern about whether someone lives or dies that it's seen as malice.
So like playing Russian roulette with someone else's gun.
That's often used as an example, yeah. The key is that extreme indifference. It's sometimes a blurry line, though, between extreme recklessness and a truly depraved heart, proving that indifference can be tough.
I can see that. Okay, so that's the common law picture, roughly. Our sources also mentioned the Model Penal Code, the MPC. How does it handle these things differently?
The MPC does shake things up a bit. For murder, it still covers intentional killings, premeditated killings, and depraved heart murder. But it also specifically addresses felony murder. And interestingly, it tells juries they can presume extreme indifference if a death occurs during certain serious felonies.
Ah, okay. What about manslaughter under the MPC? Especially voluntary manslaughter you mentioned. It uses an extreme mental or emotional disturbance standard. That sounds different from the common law categories.
It's a very different approach, much more flexible. Instead of that strict list of provocations, the MPC's EMB standard looks at two things. Was the defendant suffering from an extreme mental or emotional disturbance? And was there a reasonable explanation or excuse for that disturbance?
Reasonable from whose perspective?
This is key. It's viewed from the perspective of a person in the actor's situation, under the circumstances as the actor believed them to be. It's a kind of hybrid objective-subjective test, more individualized than the common law.
So it considers the defendant's own circumstances and beliefs more?
Yes, much more. It definitely allows for a more nuanced look at their emotional state. It does raise interesting questions, though, about balancing individual experiences against broader societal standards.
No doubt. What about involuntary manslaughter in the MPC?
Under the MPC, involuntary manslaughter generally involves recklessness, meaning the person was aware of a substantial risk of death and consciously disregarded it.
Okay, awareness of the risk is key there.
Right. And the MPC also defines a lesser crime, negligent homicide. That only requires criminal negligence, basically, failing to perceive a substantial risk that you should have perceived.
So recklessness is ignoring a known risk. Negligence is failing to see a risk you should have seen.
That's a good way to put it. Plus, lots of jurisdictions, even following MPC ideas, have rules where a death during any unlawful act, even a misdemeanor, could potentially be involuntary manslaughter.
Right. Okay, that gives a clearer picture of the MPC's structure. Now, felony murder. You mentioned it under the MPC, but it's a big topic on its own. Our sources stress the independence of the felony rule. What's that?
Super important point. For the felony murder rule to apply, the underlying felony has to be legally separate from the act that causes the death.
Meaning?
Meaning, if the felony is the act of violence that causes the death, like a simple assault that unexpectedly turns fatal, you can't usually use that assault as the basis for a felony murder charge. The felony and the killing would merge. It prevents a kind of double counting or circular reasoning.
Got it. The felony has to be something else that you were doing during which the death occurred.
Exactly. Like robbery, burglary, arson.
Okay. And how do courts decide which felonies count for felony murder? There are different approaches.
Yes, mainly two. There's the per approach, sometimes called the enumerated felonies approach.
Enumerated, like listed out.
Precisely. Some laws just list specific felonies, often inherently dangerous ones that qualify. You mentioned robbery, burglary, arson. The common mnemonic is BRARC.
Okay, what's that stand for?
Burglary, arson, rape, robbery, kidnapping. If a death occurs during one of these listed felonies, felony murder often applies, sometimes automatically as first-degree murder.
So it's like a predefined list of high-risk crimes.
Pretty much. But you always have to check the specific statute for that jurisdiction. Some have different lists, or maybe tiered systems, first degree for bulk felonies, maybe second degree for other dangerous felonies.
Okay, so check the list. What's the other approach? The as committed one.
Right, the as committed or inherently dangerous in fact approach. This looks less at the type of felony listed in a statute and more at how this specific felony was actually carried out.
So was it dangerous in this particular instance?
Exactly. Did the way the defendant committed the felony create a substantial risk of death in that situation? It's more of a case-by-case analysis of the actual danger posed by their actions. So a felony not on the BRK list might still trigger felony murder if it was done in a really dangerous way.
Okay, one is about the crime type, the other about the specific risky actions. The sources also mention needing a logical relationship, time and distance limits.
Yeah, the felony murder rule isn't endless. It generally applies during the commission of the felony and also during the immediate flight from the felony.
Fleeing the scene counts.
Usually, yes, until the felons reach a place of what the law calls temporary safety.
And who decides what's temporary safety?
That's typically a question for the jury based on the facts. Did they get away clean? Are they safe for the moment? Also, the act that actually causes the death usually has to be in furtherance of the felony.
Meaning it helped them commit the crime.
Or help them escape, yeah. Connected to the goal of the felony somehow.
So if a long time passes, or they're clearly safe somewhere else, a later death might not connect back.
That's the idea. The connection weakens. Now, another really complex bit is what happens if someone other than the felons causes the death?
Right, like if a victim fights back or the police arrive.
Exactly. This is where you get the agency versus proximate cause approaches.
Okay, break those down. Agency approach.
Agency is the majority rule. It basically says felony murder doesn't apply if the person who directly causes the death is not one of the felons or their accomplices. The killing has to be done by an agent of the felony.
So under the agency rule, if a security guard shoots and kills one of the robbers during a bank robbery, the surviving robbers probably wouldn't be charged with felony murder for their partner's death.
Generally, that's correct under the pure agency approach.
Okay. What's the alternative? Proximate cause.
That's the minority view. It says felony murder can apply if the death was a reasonably foreseeable consequence of the felony, even if the killer wasn't one of the felons.
So under that view, the robbers might be on the hook if it was foreseeable that their actions could lead to someone, like a guard or victim, causing a death.
Potentially, yes. If the death is seen as a direct, foreseeable result of the dangerous situation the felons created.
That seems like a much broader scope of liability.
It can be. There's usually still a need for a logical nexus, though. A clear causal link, often a close-time relationship. The death has to be part of the same continuous transaction as the felony.
And underlying all of this felony murder stuff is causation itself, right? Actual and proximate.
Absolutely fundamental. You need both. Actual cause. But for the felony, the death wouldn't have happened. And proximate cause. Was the death a foreseeable or natural result of committing that felony? You usually need to establish both links.
Okay, wow. Felony murder is definitely a tangled web.
It really is. State laws vary hugely on it, too.
All right, we've spent a lot of time on homicide. Let's move to some other important crimes against the person. Starting with battery. Our notes say it's a general intent crime. What does that mean, practically?
It means the prosecution doesn't have to prove you specifically intended the harmful result. They generally only need to show you intended the action that caused the harmful or offensive contact, and that you acted with at least criminal negligence regarding the outcome. The focus is more on the unlawful act itself.
And the contact has to be harmful or offensive. Offensive doesn't necessarily mean painful.
Correct. Harmful is pretty straightforward, causes pain or injury. Offensive means contact that would violate a reasonable person's sense of personal dignity, like spitting on someone, maybe, even if it doesn't physically hurt them. Unwanted touching.
Gotcha. And then there's aggravated battery. What bumps it up?
Aggravated battery is usually a felony. The aggravating factors are things that make the battery more serious. Common ones include using a deadly weapon, causing serious bodily injury, or targeting a vulnerable victim like a child, an elderly person, or a police officer.
Okay, so specific circumstances escalate it. Now, assault. This one seems tricky because common law and the MPC define it differently.
Yes, there are some key differences to track. Under the common law, simple assault can actually be two different things.
Two things?
Yeah. First, it can be an attempted battery. You tried to commit a battery, like swung and missed but failed. Requires the specific intent to actually cause the contact.
Okay, tried to hit someone but didn't connect. What's the second type?
The second type is sometimes called an intent to frighten assault. This is where you intentionally act in a way that makes the victim reasonably fear an imminent battery.
So you don't even have to try to hit them, just make them think you're about to.
Exactly. The key elements are the intent to cause that fear, the victim's reasonable apprehension of immediate harm, and your apparent ability to carry it out. The victim has to be aware of the threat for this type.
Ah, so awareness is key for the fear type, but maybe not for the attempted battery type if they didn't see it coming.
Right, and just like battery, common law has aggravated assault too, based on similar factors: deadly weapons, serious injury, vulnerable victims, intent to commit a more serious crime.
Okay. How does the MPC handle assault then?
The MPC streamlines it a bit. Simple assault under the MPC is generally a misdemeanor. It includes attempting to cause or recklessly causing bodily injury, or negligently causing injury with a deadly weapon, or trying to put someone in fear of imminent serious bodily injury using physical menace.
So recklessness and negligence can be enough for simple assault under the MPC in some cases.
Yes. And then aggravated assault under the MPC is a felony. That involves attempting to cause serious bodily injury, or actually causing it purposely, knowingly, or recklessly under circumstances showing extreme indifference to human life, or attempting to cause or causing any bodily injury with a deadly weapon.
And the MPC gives definitions for bodily injury, serious bodily injury, deadly weapon.
Which is really helpful for clarity. Bodily injury is basically any physical pain, illness, or impairment. Serious bodily injury involves substantial risk of death, permanent disfigurement, or long-term loss or impairment of a body part or function. And a deadly weapon is basically anything capable of causing death or serious injury by how it's used or intended to be used. A gun, a knife, but maybe even a heavy object depending on the context.
Those definitions definitely seem important for applying the different levels of assault. Okay, 2 more. False imprisonment and kidnapping. They seem related.
Very related. False imprisonment is the foundation. It's the unlawful, intentional confinement of another person without their consent.
Confinement meaning locked in a room.
Could be, but doesn't have to be. It just means restricting their freedom of movement significantly without a reasonable means of escape. It could even be through threats that keep someone from leaving.
Okay. And kidnapping builds on that.
Exactly. Kidnapping includes all the elements of false imprisonment. So false imprisonment is a lesser included offense. But kidnapping requires something more. Either moving the victim from one place to another, asportation.
Even a short distance.
Yes, in many places, even a short distance counts. Or concealing the victim in a secret place. So it's false imprisonment, PLUS, either movement or concealment.
And aggravated kidnapping.
Similar to other aggravated crimes, kidnapping becomes aggravated with higher penalties if it's done for ransom or to facilitate another crime or causes serious injury, things like that.
Right. Okay, last one on our list. Stalking. This feels different, more about a pattern over time.
That's the absolute key. Stalking isn't usually about a single incident. It's defined by a course of conduct, repeated actions directed at a specific person.
What kind of actions?
It can include following, monitoring, harassing, communicating with, even non-threateningly if it's unwanted and repeated, or making threats. The conduct has to be such that it would cause a reasonable person to fear for their safety or suffer substantial emotional distress.
And it's the whole pattern, the totality of the circumstances that matter.
Exactly. One unwanted phone call might not be stalking, but dozens. Or showing up repeatedly at someone's home or work. That pattern creates the fear and distress the law targets.
Okay, so it's the repeated nature and the fear it reasonably causes. Well, we have definitely gone through a lot of legal ground here, from the nuances of different degrees of murder and manslaughter.
All the way down to battery, assault, kidnapping, stalking,
It really highlights how the legal system tries anyway to categorize harm based on intent, actions, circumstances, results.
It does. And understanding these distinctions, even basically, is pretty important for, just understanding news reports, court cases, or even just the basis of our criminal law.
Absolutely. And, wrapping this up, it really makes you think about that fundamental challenge, doesn't it? The law needs these categories, these objective standards like reasonable person or adequate provocation.
Right, for consistency.
But it's trying to apply them to incredibly complex, messy, subjective human situations involving intense emotions, impaired judgment, unique personal histories. How does the system really balance those objective rules with the subjective reality of the people involved?
That's the million-dollar question, isn't it?
Yeah.
There's always that tension. It's definitely something to mull over.
Indeed. Well, thanks for taking this deep dive with us today. Welcome to the deep dive. Ever wondered when just thinking about a crime or maybe talking about it can actually land you in legal trouble?
Yeah, it's a fascinating area of law.
Today we're plunging into that space, the world of inchoate crimes. These are essentially incomplete criminal acts where the law steps in, well, before the main crime actually happens.
Exactly. It's like the law is looking at the steps leading up to something potentially harmful. We're going to focus on three main types. Solicitation, that's asking someone to commit a crime.
Right.
Then conspiracy, which is about agreeing with others to commit one. And finally, attempt, where you actually start taking, significant steps toward doing the crime yourself.
And to really get our heads around this, we'll be looking at it through two main lenses, right? The traditional common law, the rules built up over centuries.
Court cases, yeah.
And then the more modern approach, the Model Penal Code, or MPC. And you'll see they don't always line up. There are some really key differences.
Definitely. Our mission today really is to cut through some of that legal jargon and give you a solid understanding of how and when the law intervenes before a crime is actually completed. We want you to leave feeling informed, not, buried in legal texts.
Sounds like a plan. So where do we kick off? Maybe with solicitation, asking someone to commit a crime.
Good place to start. So under common law, solicitation is pretty much what it sounds like. Asking, inviting, requesting, commanding, even just encouraging someone else to commit a crime.
But there's a catch, right? You have to actually mean it.
Absolutely. You have to genuinely intend for them to go through with it. And historically, under common law, this often applied mainly to serious crimes, felonies, or misdemeanors that were seen as a breach of the peace.
Okay, so not necessarily asking someone to, I don't know, jaywalk?
Probably not under the old common law view. And there's this concept, the guilty hand. The idea is the crime of solicitation is done, it's complete, the moment you say those words with that criminal intent.
The words themselves are the act.
In essence, yes. The asking is the illegal act, provided the intent is there.
Guilty hand. That's quite a term. It really shows that idea of trying to stop crime before it starts. But like you said, it's not just the words, there's the guilty mind too.
Precisely. You have to actually intend for the crime to happen. If you're clearly joking, or maybe just being incredibly reckless, but not actually wanting the crime committed, that usually wouldn't cut it under an objective standard. The specific intent is crucial.
Right. And what about free speech? I mean, where's the line?
That's a really important point. First Amendment limitations definitely come into play. If someone, say, writes a pamphlet arguing generally that people should resist unfair laws, that's almost certainly protected speech.
Not solicitation.
Not solicitation. Courts look for something much more specific, urging a particular person or group to commit a specific crime, right then or very soon. It needs to be a direct call to criminal action, not just broad political talk.
Okay, that distinction makes sense. Now, solicitation is different from actually trying to commit the crime yourself, right? It's not attempt.
Correct. Asking someone to rob a bank is solicitation. Putting on the mask and heading towards the door yourself, that starts moving towards attempt. They're distinct stages.
And under common law, if you solicit someone, can you just take it back, say, oops, never mind?
Nope. Under the traditional common law view, renunciation, taking it back, is generally not a defense. Once you've made the illicit request with intent, the crime of solicitation is considered complete.
Okay, so that's the common law picture. How does the Model Penal Code handle solicitation? Is it different?
It is, in some key ways. First, the MPC's view is broader. It applies to soliciting any crime, not just felonies or breaches of the peace.
Any crime at all.
Any crime. The MPC definition focuses on acting with the purpose of promoting or facilitating its commission. This could be by commanding, encouraging, or requesting someone to commit the crime, or attempt it, or even just become an accomplice. The net is definitely wider.
So the MPC is maybe a bit more focused on stopping potential crime even earlier, regardless of seriousness. What about this idea of uncommunicated solicitation in the MPC? That sounds odd. How can it be solicitation if the other person never even gets the message?
Yeah, it's an interesting concept. The MPC's logic here is that the danger lies in the solicitor's intent and actions. So if you say, write and mail a letter asking someone to commit a crime, but the letter gets lost. Under the MPC, you could still potentially be guilty of solicitation because your conduct was designed to communicate that request with criminal intent. The focus shifts a bit from whether the message was received to your own culpable actions and purpose.
Wow, that's quite different from the common law's guilty hand needing the words to be spoken or communicated. But the First Amendment protections, those still apply under the MPC.
Oh, absolutely. The same principles apply. General advocacy is protected. Specific incitement to imminent crime is not.
Okay, now you said common law doesn't allow taking back a solicitation. What about the MPC? Does it recognize renunciation?
Yes, and this is a really significant difference. The MPC does allow renunciation as a defense. If you completely and voluntarily abandon your criminal purpose.
Voluntarily meaning like a real change of heart, not just getting scared.
Exactly. Not because you think you're about to get caught. If you have that genuine change of heart, and you either persuade the person you solicited not to do it, or you otherwise manage to prevent the crime from happening,
Then you might have a defense.
then you might have a complete defense to the solicitation charge under the MPC. It actually encourages people to undo the harm they might have set in motion.
That seems practical, actually. Okay, one last thing on solicitation. The merger doctrine. What's that about?
Right. Merger. Basically, it means you usually can't be convicted of both solicitation and the crime you solicited if it actually gets committed. The solicitation merges into the completed offense or into conspiracy if an agreement is formed.
So if you ask someone to rob a bank and they do it, you'd likely face robbery charges, maybe conspiracy, but not a separate charge for the initial asking.
That's the general idea. The solicitation is seen as a preliminary step.
Oh.
Okay, shall we shift gears to conspiracy? That's often seen as, well, a step further down the road.
Let's do it. Conspiracy. So under common law, this is all about the agreement, right? Two or more people agreeing to commit a crime.
That's the heart of it. An agreement, a meeting of the minds to achieve an unlawful goal. And a really crucial point here, unlike solicitation, conspiracy under common law does not merge.
Doesn't merge. What does that mean in practice?
It means you can be found guilty of both the conspiracy, the agreement, and the crime you conspired to commit if it's actually carried out.
Whoa. So agree to rob the bank, then rob the bank. You could face charges for both the agreement and the robbery.
Potentially, yes. It highlights just how seriously the law views forming these criminal pacts.
Yeah.
It's seen as dangerous in itself because groups can often achieve more and more dangerous things than individuals.
That makes sense. Okay, what about this term attendant circumstances in conspiracy? Sounds a bit technical.
It can be, but the core idea is this. Sometimes, for a crime to be a specific offense, certain facts or conditions the attendant circumstances need to exist. Like, for assaulting a federal officer, the victim needs to actually be a federal officer.
Okay.
Now, in a conspiracy context, let's say you agree with someone to assault a bank teller during a robbery. You just intend to commit the assault. If it turns out unknown to you, that teller was an undercover federal agent, you could still potentially be guilty of conspiracy to assault a federal officer, even if you didn't know their status. The intent to commit the underlying criminal act, the assault, is often enough. Your ignorance about that specific circumstance might not be a defense. It's almost like strict liability for that particular fact within the conspiracy charge.
Got it. So the focus is on agreeing to the act. And some surrounding facts might add legal weight even if you weren't aware of them. But you do need intent for the act itself, right? You can't conspire to be reckless.
Exactly. Conspiracy generally requires a specific intent to commit the target crime. You typically can't conspire to commit crimes defined by recklessness or negligence.
But what if you make a mistake about the facts? Like, you agree to steal a box thinking it's empty, but it secretly contains, I don't know, stolen jewels.
Well, an unreasonable mistake of fact could potentially be a defense if it means you lacked the necessary intent for the specific crime you're charged with conspiring to commit. It gets complex, but mistake can sometimes negate intent.
Okay, so let's nail down the essential ingredients. What does a prosecutor need to show to prove a common law conspiracy?
All right, there are a few key elements. First, obviously, an agreement between two or more people. This doesn't have to be a written contract or anything formal.
Could be just a nod.
It could be implied from actions, a shared look, people working together in a way that clearly shows a common criminal plan. Direct communication isn't always needed, but that shared intent has to be there. Second, there needs to be this communion of understanding. Everyone needs to be on the same page about the criminal goal. Third, the goal itself must be to commit a crime, or under some older common law views, maybe even just a generally unlawful act like a serious civil wrong. And finally, you need the intent to actually enter the agreement, and the intent for the crime itself to be achieved. Multiple layers of intent.
That sounds like a lot to prove. Does common law require them to actually do anything towards the crime beyond just agreeing, like an overt act?
Generally, for most serious crimes like felonies under common law, the answer is no. The agreement itself, with the criminal intent, is often enough to constitute the crime of conspiracy.
Just the agreement, wow.
Yeah, the law views the agreement itself as the primary danger here, the
Yeah.
plotting, the collaboration.
That really underscores the preventative aspect. Now, proving that shared intent, especially if someone's just, say, supplying materials.
Yeah.
That seems tricky, this purpose versus knowledge thing.
Oh, it's definitely one of the trickiest areas. If someone's directly involved, planning or carrying out the crime, intent is usually clear. But what if someone's, say, selling chemicals that could be used legally, but they know their buyer is using them to make illegal drugs?
Right. Are they part of the conspiracy?
Courts often look to see if the supplier has a stake in the venture. Are they charging inflated prices? Are the quantities huge? Do the materials have few legitimate uses? Is their business basically dependent on this illegal activity? If so, a jury might infer they share the criminal purpose, not just knowledge.
So it's more than just knowing. It's about being invested in the criminal outcome.
Often, yes. Also, there's sometimes a distinction based on the type of crime. For things inherently wrong, like murder, malum in se, the agreement itself implies a corrupt motive. For things wrong just because a law says so, malum prohibitum, prosecutors might need stronger proof the conspirators knew it was illegal or had a specific corrupt intent.
Okay, that distinction helps. Now, Pinkerton liability sounds ominous. What's that?
It is a powerful doctrine. Pinkerton liability under common law means that once you're a member of a conspiracy, you can be held responsible for other crimes committed by your co-conspirators.
Even if you weren't there or didn't know about that specific crime.
Exactly. If those crimes were committed to further the conspiracy's goals and they were a reasonably foreseeable result of the conspiracy, you have to be a member when the crime happens. But yeah, you don't need direct involvement in that secondary crime.
Give me an example.
Okay, say you agree with others to distribute drugs. Your role is just finances. If one of your co-conspirators carries an illegal firearm during a drug deal, which is pretty foreseeable in drug trafficking, you could potentially be charged with a firearm offense too, under Pinkerton, even if you never touched the gun.
Wow. So joining a conspiracy really exposes you to a liability for what others in the group might do. How do you get out of that? Can you withdraw from a common law conspiracy?
You can try, but it's tricky. Under common law, withdrawal generally doesn't erase your guilt for joining the conspiracy in the first place. The agreement already happened.
So you're still guilty of conspiracy?
Usually, yes. But withdrawing can potentially shield you from Pinkerton liability for future crimes your former co-conspirators commit after you've effectively withdrawn.
How do you effectively withdraw? Just stop showing up.
Typically, no. You usually need to take some clear, affirmative step to communicate your withdrawal to your co-conspirators. Simply becoming inactive often isn't enough. And importantly, things like the police arresting someone or the goal becoming impossible don't automatically count as withdrawal. You need to actively pull out.
So you need to make a clean break and make it known. Okay. What about Wharton's rule? Is that like a loophole?
It's more of a specific limitation, traditionally. Wharton's rule basically said you couldn't charge conspiracy for crimes that, by their very definition, require two people to commit them. Think dueling, adultery, bribery, maybe a simple drug sale between just a buyer and seller.
Because the crime itself already includes the agreement part.
That was the logic. Charging conspiracy seemed redundant. However, the modern trend is definitely moving away from a strict application of Wharton's rule. Many places now do allow conspiracy charges for these crimes, especially if the legislature seems okay with it, or if there are more people involved than strictly necessary for the base crime.
So it's less of a shield than it used to be. Now, I've heard about different conspiracy structures, chains, and wheels.
Right. These are just ways to visualize complex conspiracies. A chain conspiracy is linear, like steps in a process. Think drug manufacturing, then distribution, then sales. Each link connects to the next, working towards one big goal.
And a wheel.
A wheel or spoke conspiracy has a central person or group, the hub, who makes separate agreements with different individuals or groups. The spokes might not know each other. Think of a mob boss dealing with separate crews.
So are all the spokes liable for what other spokes do?
Not necessarily. Usually, a spoke is only liable for the agreement they have with the hub, unless they know about the larger operation and share a community of interest with the other spokes, meaning they all benefit from or contribute to the overall success of the hub's larger scheme.
Okay, that paints a good picture of the common law approach. How does the model penal code shake things up for conspiracy?
The MPC introduces some really significant changes. Probably the biggest is the general requirement of an overt act.
So Unlike common law, the MPC usually does require someone to take a step.
Yes. In most MPC conspiracy cases, though, there's an exception often carved out for the most serious felonies. At least one person in the conspiracy needs to perform some act, any act, to help move the plan forward. It doesn't even have to be an illegal act itself.
Just something, like buying supplies.
Exactly. Buying ski masks for robbery, scouting a location, something tangible to show the agreement isn't just talk. And importantly, if one conspirator performs an overt act, that satisfies the requirement for everyone in the conspiracy.
Okay, so a concrete step is usually needed. What about that Pinkerton liability we talked about? Holding people responsible for foreseeable crimes of others.
Gone. The MPC explicitly rejects Pinkerton liability.
Really? So under the MPC, you're generally only liable for the conspiracy itself and the crimes you personally commit or aid.
That's the main thrust. Liability is much more individualized under the MPC approach to conspiracy. It avoids that broad, sweeping liability for co-conspirators' actions just because they were foreseeable.
That's a huge difference. What about Wharton's rule, the one about crimes requiring two people? Does MPC keep that?
Nope. The MPC essentially gets rid of Wharton's rule too. It says that you can conspire to commit any crime, even ones like bribery or dueling, that inherently need multiple people. The focus is purely on whether there was an agreement with the purpose to promote or facilitate any criminal act.
So conspiracy charges are potentially broader for those specific types of crimes under the MPC. How does withdrawal work in the MPC? Is it easier than common law?
The MPC does provide a clearer path for withdrawal as a defense, but the rules depend on timing. If you withdraw before anyone commits an overt act, and it's a complete involuntary withdrawal, it can be a complete defense to the conspiracy charge itself.
Wow, okay. And if an overt act has already happened?
If an overt act has occurred, the conspiracy is technically complete. But withdrawing after that point can still save you from being liable for the target crime itself and any future acts of the others. But to make that work, you generally have to not just withdraw, but actively try to thwart the conspiracy's success.
How do you do that? Tell the police.
That's often the most effective way informing law enforcement. Or you need to communicate your abandonment clearly to all your co-conspirators in time for them to abandon it too. It requires actively trying to stop the train, not just jumping off.
Got it. More proactive than common law. Now, I remember you mentioned the MPC uses a unilateral approach to conspiracy. Common law needed two guilty minds, right?
Exactly. Common law was traditionally bilateral. You needed at least two people genuinely agreeing to commit the crime. The MPC is unilateral. This means a conspiracy can exist even if only one person involved has actual criminal intent.
So, you could conspire with an undercover cop.
Precisely. If you genuinely intend to commit the crime and you make an agreement with someone, even if they're faking it, like an officer, you can be guilty of conspiracy under the MPC's unilateral view. The focus is on your culpable state of mind and agreement.
That's a fundamental shift. Okay, and quickly, chain and wheel conspiracies under the MPC. Similar idea.
Largely similar concepts, yes. The structure is analyzed similarly, and that idea of a community of interest is still key for determining the scope, especially in wheel conspiracies. The MPC also clarifies that if you know your immediate partner is conspiring with others in a larger scheme, you can be considered part of that larger conspiracy too. One agreement can cover multiple planned crimes if they're part of the same overall relationship or venture.
All right. That covers a lot on conspiracy. Let's tackle the last one. Attempt. Taking steps but not quite finishing the job.
Right. Attempt is that bridge between planning and completion. It requires two key things: the intent to commit the specific crime, the mental part, and some kind of action moving towards it, the conduct part.
And it's usually punished less severely than actually succeeding, I assume.
Generally, yes, though the law can specify otherwise. The idea is to penalize taking those dangerous steps, but acknowledging the ultimate harm didn't occur.
Now, you said intent is key. How specific does that intent have to be for attempt?
Extremely specific. This is crucial. Attempt requires specific intent to bring about the criminal result. This means you generally cannot attempt crimes that are defined by lower mental states like recklessness or negligence.
So no such thing as attempted involuntary manslaughter.
Correct. Or attempted reckless endangerment, or attempted felony murder. Those crimes don't require the conscious objective to cause the specific harmful result in the same way, so you can't legally attempt them. You have to specifically intend the crime you're attempting.
Okay, crystal clear intent needed. Now, the big question with attempt is always, when does just preparing cross the line into actually attempting? Common law had a bunch of different tests for this, didn't it?
Oh, definitely. This line between preparation and perpetration has always been tricky. Well, the MPC's substantial step test is very influential now. Common law courts developed several ways to try and pinpoint that line.
What were some of them?
Well, there was the physical proximity test. This one's pretty strict. It looks at how close the person was in time, space, and action to actually finishing the crime, what was left to be done.
So almost at the finish line.
Pretty much. Then there's dangerous proximity.
Yeah.
A bit more flexible. It weighs how close the person was against how much danger their actions created
Right.
and how likely they were to succeed if not stopped. The greater the danger and likelihood of success, the less physical closeness might be needed.
Okay, that makes sense. What else?
There's the indispensable element test. Does the person have everything they absolutely need to commit the crime? Have they secured the final essential tool or piece of information? Another is the probable desistance test. It asks, has the person gone so far that an ordinary law-abiding person in their shoes would likely have stopped unless they genuinely intended to go through with it? The idea is they're past the point of likely turning back on their own.
Like a point of no return, behaviorally speaking?
Kind of, yeah. And finally, the unequivocality test, sometimes called res ipsa loquitur. The act speaks for itself. Does the person's conduct, viewed objectively, leave no reasonable doubt about their criminal intent? Can you think of any innocent explanation? Some courts using this test only look at the actions. Others might consider confessions or other evidence of intent too.
So common law really tried various angles to define that moment of attempt. What about attendant circumstances for attempt in common law? Same rules as for the completed crime.
Generally, yes. You usually don't need a higher mental state regarding those surrounding facts for the attempt than you would for the completed crime. If the main crime requires knowledge of a fact, the attempt likely does too. If the main crime has strict liability for a fact, the attempt likely does too.
And withdrawal. If you start attempting under common law, can you back out and have a defense?
Generally, no. Under the dominant common law view, once your actions cross that line into attempt, the crime is complete. Abandoning the effort after that point usually isn't a defense.
The attempt itself is the punishable act. Okay, now, impossibility. This always seems confusing. What if you try to do something that's actually impossible, like trying to pick an empty pocket? Common law view.
Right, impossibility. Common law usually says factual impossibility like the empty pocket, or trying to shoot someone with an unloaded gun you thought was loaded, is not a defense. You intended the crime, you took steps. The fact that some unknown circumstance prevented success doesn't excuse the attempt.
Okay, what about trying to do something you think is illegal, but it's actually not?
That's usually called legal impossibility. Generally, also not a defense if the acts you intended, under the circumstances as you believe them to be, would have been a crime. However, pure legal impossibility where the act you set out to do is simply not criminal at all, like trying to import something you think is banned but actually isn't, there usually is a defense under common law.
So it really hinges on what you thought you were doing and intended.
Largely, yes. There's also inherent impossibility trying to kill someone with voodoo. Usually not a defense, but maybe considered at sentencing because it was so obviously doomed to fail.
Okay, that clarifies the common law stance. Now let's switch to the MPC's approach to attempt. They have that substantial step test, right?
Yes, and it's become very influential. The MPC says you're guilty of attempt if, acting with the required criminal intent, you take a substantial step in a course of conduct planned to result in the crime. And crucially, that step has to be strongly corroborative of the actor's criminal purpose.
Strongly corroborative. So the step itself has to really point towards criminal intent.
Exactly. And the MPC even gives helpful examples of things that can be a substantial step, though it's not an exhaustive list. These like lying in wait, searching for or following the victim, casing the place where the crime will happen, unlawfully entering the location, possessing materials specially designed for the crime that have no lawful use for you.
Like burglary tools.
Right? Or possessing, collecting, or fabricating materials to be used in the crime near the scene, even soliciting an innocent person to do part of the crime for you. These actions clearly signal you're moving past just thinking about it.
Those examples make it much clearer. What about attendant circumstances and intent under the MPC for attempt? Similar to common law.
Pretty similar, yes.
Yeah.
You generally need the same mental state regarding attendant circumstances as required for the completed crime itself. No heightened requirement just because it's an attempt.
And the MPC has this thing called complicity to attempt. What's that?
Yeah. This basically means if you help or encourage someone else with the purpose that they commit a crime, you can actually be guilty of the attempted commission of that crime yourself, even if the person you are helping never actually gets far enough along to attempt it themselves.
So you can be liable for attempting a crime just by trying to get someone else to do it, even if they bail.
Under the MPC's complicity rules, potentially yes. It links accomplice liability to the inchoate stage.
Interesting. Now, withdrawal. Common law generally said no defense for attempt once you start. Does the MPC allow it here, like it did for solicitation and conspiracy?
Yes, it does.
Yeah.
This is another major difference. The MPC does recognize abandonment or renunciation as a defense to attempt.
But there must be conditions, right?
Absolutely. The abandonment must be complete. You have to totally give up the criminal effort, not just postpone it or switch targets. And it must be voluntary. A genuine change of heart, not because you got scared, ran into unexpected difficulty, or thought the cops were coming.
So a true internal decision to stop.
Exactly. And crucially, it's not a defense if the attempt was already completed, like firing a shot that misses, or if your abandonment only happened after you caused harm or completed part of the crime, requiring attempt liability. Involuntary abandonment because you got caught or something made it impossible doesn't count.
So the MPC again provides an incentive to genuinely turn back, even after taking substantial steps. What about impossibility under the MPC? Does it follow the common law idea that factual impossibility isn't a defense?
Largely, yes. The MPC generally agrees that factual impossibility, the empty pocket, the unloaded gun, is not a defense to attempt. If the crime could have happened under the circumstances as the person believed them to be, they can still be guilty of attempt. Similarly, legal impossibility, as common law defined it, is generally not a defense either. The focus remains firmly on the actor's criminal purpose and the substantial steps they took.
So both systems really zero in on the person's intent and actions, not whether their plan was actually workable in reality.
That's a good way to put it. The danger lies in what they tried and intended to do.
Well, this has certainly been a thorough deep dive into these preliminary crimes. We've really unpacked solicitation, the asking,
Conspiracy, the agreement.
and attempt those significant steps towards the final act.
And hopefully we've made clear some of those key differences between the older common law rules and the more modern model penal code approach things like needing an overt act, that whole Pinkerton liability issue, Wharton's rule, and especially whether you can actually withdraw and potentially have a defense.
Right. Understanding these nuances is pretty vital, I think, for grasping how the law tries to balance preventing harm with principles of fairness and individual responsibility even before a crime fully unfolds.
Absolutely. And it leaves us with a thought maybe for you to consider.
Yeah.
As society changes, especially with new technologies, new ways of communicating, maybe even virtual interactions, how might our understanding of these inchoate crimes need to evolve? What does agreement mean in a massive online group? What constitutes a substantial step in cyberspace? What are the ethical lines when we talk about solicitation or conspiracy in these new contexts?
Yeah.
It definitely raises some complex questions for the future.
That's a really fascinating point to ponder. Definitely food for thought. Thanks for joining us on this deep dive. We'll catch you next time.
Ever thought about how when a crime goes down, it's not always just the main person who did the thing that gets into trouble?
Oh, absolutely. The legal responsibility can spread out quite a bit.
It's kind of fascinating and maybe a bit surprising sometimes.
It really is. And that's actually what we're getting into today, this whole idea of being legally responsible for what other people do.
Right.
Specifically, we're looking at complicity in criminal law. Basically, when and how you might be held accountable for a crime you didn't physically commit yourself.
Yeah, like maybe someone planned it or drove the getaway car or even just, I don't know, egged the main person on.
Exactly, those kinds of situations.
So this deep dive is going to unpack the legal rules that decide when that kind of indirect involvement crosses the line.
And to do that, we'll be looking at two main ways the law handles this. First, there's the common law approach. That's the law built up over time through court decisions.
Okay.
And second, we'll explore the model penal code, the MPC, which is a more, let's say, modern attempt to organize and standardize criminal law.
Gotcha. So common law versus the MPC. We're going to see how actions that might seem small or sometimes even not acting can have pretty big legal fallout under these different systems.
Precisely. It's about understanding those lines.
All right, let's jump in. Common law complicity. What's the basic idea of being an accomplice in that system?
Well, under common law, you're looking at essentially four key things to make someone an accomplice.
4 things, okay.
First, they need to have actually provided some kind of assistance or encouragement to the main person, the principal offender.
Assistance or encouragement, how much?
That's the interesting part. Even a little bit of real help can be enough. Just trying to help, though, that usually doesn't count unless the attempt itself gave the principal a boost, encouraged them.
Yeah.
And definitely, if you ask someone to commit a crime solicitation, that counts as encouragement. And crucially, the help doesn't need to be like the main reason the crime happened. Just making it easier could be enough.
Wow, okay. So even a small push, legally speaking, could be significant under common law. What's number 2?
The second part is that this help or encouragement has to be directed towards another in the commission of a crime. Pretty straightforward. There needs to be someone else actually doing the crime. You can't be your own accomplice.
Right, makes sense. What about what's going on in their head, the mental side?
That's the third element, and it's got 2 parts. The person has to have intended to actually do the helping or encouraging action.
Okay, intended to help.
And they also have to have intended for the actual crime they're helping with to be committed. So it's a purpose thing. More than just being aware something bad might happen, you need a sort of stake in the venture.
A stake in the venture. I like that phrase.
Yeah. Although it's worth noting, juries might find that purpose, that intent, a bit more easily when the crime involved is really serious, like life-threatening stuff.
So it's deliberate, not just accidentally helping someone trip into a bank vault. And the fourth element.
The fourth just ties it together. The help or encouragement has to be connected to the crime that actually happened.
Got it. So assistance for another person with the intent to help and for the crime to happen, and it's linked to the actual crime.
You nailed it. Now, what counts as assistance or encouragement, that can be pretty broad under common law.
Okay, give us some examples. What kind of things are we talking about?
Well, just saying, yeah, go for it. Or showing approval while the crime is happening could be enough, showing you share their intent. There's also this idea of a community of purpose. If you stick around and keep participating in something, knowing the main person has criminal plans, well, your continued involvement can imply you share that criminal intent.
So staying involved sends a message.
It can. And even not doing something can count as help if you actually have a legal duty to step in and prevent the crime. Like a security guard who just watches a theft they could stop.
That's a big one. Failing to act when you're supposed to. What about just being there? Like you're standing on the street corner and a robbery happens right next to you.
Generally, just being present isn't enough to make you an accomplice. But if your being there is part of a prior plan, or if you do something while there that encourages the person, then it could be.
So presence plus something else.
Right. Just passively standing by, even if you're there the whole time, usually isn't encouragement unless there was that prior agreement or some other signal of support.
Okay.
And here's a tricky one. Sometimes, even just promising not to interfere could be enough to count as encouragement.
Wow. Okay, so there's a whole range here from active pushing to sort of enabling through agreement. What if you help plan something but then get cold feet? Can you back out?
Good question. Under common law, timing is key. Once the crime is totally finished, you can't undo being an accomplice.
Too late then.
Right. If you did help or encourage, just changing your mind later doesn't wipe the slate clean. To effectively withdraw before the crime happens, you really have to fully stop your involvement.
Completely stop.
And you need to do it early enough so the main players actually have a chance to reconsider because you've pulled out. And importantly, whatever you do to withdraw has to cancel out the help you already gave.
So yelling, maybe don't, as they speed away, probably doesn't count as effective withdrawal.
Probably not, no. It likely wouldn't deprive your earlier help of its effectiveness.
Now, common law also had different labels for accomplices, didn't it? Like different roles.
Yes. Traditionally, 4 classifications. First is the principal in the first degree. That's the main actor or actors. The person, actually doing the core criminal act. Usually they're at the scene.
The doer. Okay.
Then, principal in the second degree. These are helpers generally present during the crime. They might not be the main actor, but they're assisting somehow while it's happening, maybe keeping watch or driving the car right there.
On-scene helpers.
Exactly. And interestingly, their help doesn't have to be absolutely essential, like a but-for cause. If it just made the crime easier to pull off, that could be enough.
Got it. What about people who helped before it all went down?
They were called accessories before the fact. These are the folks who helped before the crime happened and weren't actually present when it did. Like the person who supplied the tools or helped map out the plan days earlier.
Pre-crime assistance, not present, Makes sense. And the last one sounds like it's about after the fact.
You got it. Accessory after the fact. Now, this is important. They aren't considered an accomplice to the original crime.
Oh, okay. Different category entirely.
Yes. They're guilty of a separate, distinct crime. This is someone who, after the main crime is totally finished, knowingly helps the offender avoid getting caught or going to trial or being convicted.
So hiding a fugitive doesn't make you part of the original robbery, but it's still a crime itself.
Exactly right. It's a separate offense. Now, there's one more really key common law concept we need to cover. Natural and foreseeable consequences.
Okay, that sounds significant. What does it mean?
It's huge. Basically, under common law, an accomplice isn't just liable for the specific crime they intended to help with. They can also be held liable for any other crimes the principal commits that were a natural and probable consequence of that first crime they helped with.
Whoa. So unintended consequences.
Yes, potentially. And these other crimes don't have to be like super serious felonies or involve a death. If it was a reasonably foreseeable outcome of the crime you did help with, you could be on the hook.
So let's say you agree to help someone shoplift. Just minor theft. But then they panic and punch a security guard. Under common law.
Under common law, if that assault was seen as a natural and foreseeable result of attempting the shoplifting, you, the accomplice to the shoplifting, could potentially also be found liable for the assault, even if you never intended for anyone to get hurt.
Wow. That really expands the potential liability, doesn't it?
It does. It highlights the significant risk involved in getting mixed up in any crime, even if you think your part is small.
Definitely something to think about. Okay, so that's the common law picture. How does the Model Penal Code, the MPC, handle all this? Does it change things up?
It does, in some pretty important ways. The MPC aimed for a more logical and consistent approach.
So what's its starting point on accountability?
The MPC begins broadly. It says you're guilty of a crime if you commit it yourself, obviously, or if someone else commits it and you are legally accountable for what they did.
Yeah, okay, standard enough. When are you legally accountable for someone else under the MPC?
The MPC lays out three main situations. First, if you, acting with the required mental state for the crime, get an innocent person or someone not legally responsible, like maybe a child or someone insane, to commit the crime for you.
Okay, using an innocent agent.
Second, if the law itself, either the MPC or the specific statute defining the crime, just says you're accountable for another's conduct in that situation.
So the law spells it out.
And third, and this is our main focus, if you are an accomplice of the other person in committing the crime.
Ah, so being an accomplice is still the core way you share liability. But how does the MPC define accomplice? Is it the same four elements as common law?
It's different and arguably more focused. Under the MPC, you're an accomplice if you act with the purpose of promoting or facilitating the commission of the offense. That purpose part is key.
Purpose. Stricter than intent.
Generally considered so, yes. It means it has to be your conscious objective that the crime succeeds. And you show this purpose by doing certain things, soliciting the other person, asking them to do it,
Okay.
or aiding them, agreeing to aid them, or even just attempting to aid them in planning or committing the crime. Note that attempting to aid is enough under the MPC, even if your attempt fails or the main person never even tries the crime.
Interesting. Attempting to aid counts. What else?
Also, like common law, if you have a legal duty to prevent the crime and you fail to make a proper effort to do so, or again, if some specific law says your conduct makes you an accomplice.
So that purpose requirement seems like a major shift from common law's intent rules.
It absolutely is. It narrows the focus. The MPC really wants to see that the helper shared the criminal purpose of the principal for that specific crime.
What about those natural and foreseeable consequences? If you help with crime A and crime B happens unexpectedly, is the accomplice still liable under the MPC?
Generally, no. The MPC specifically rejects that common law doctrine, and also something similar called Pinkerton liability from conspiracy law.
Rejects it entirely.
Pretty much for accomplice liability. Under the MPC, you're typically only liable for the crime or crimes you actually had the purpose to help bring about, those unforeseen side crimes. Usually the accomplice isn't on the hook for those.
That's a massive difference. So your liability is tied much more tightly to your actual goal.
Exactly. It avoids that potentially sprawling liability we saw under common law.
How else does the MPC differ? What about those old common law categories, principles, accessories?
Gone. The MPC gets rid of those distinctions, principal in the first degree, second degree, accessory before the fact.
Really? So what are they called?
If you meet the MPC definition of an accomplice, you're just an accomplice, sometimes referred to as accomplice in principle. It simplifies things greatly. Everyone who intentionally helps or encourages is essentially treated under the same liability umbrella.
Okay, that does sound simpler. Now, you stress the purpose requirement for helping the crime itself. But what if the crime involves, say, recklessness or negligence,
Yeah.
like involuntary manslaughter, where you don't intend the death?
Great question. That's a crucial nuance in the MPC. For those kinds of crimes, where the harm results from reckless or negligent behavior, the MPC adjusts the mental state needed for the accomplice.
Adjusts how?
The accomplice doesn't need to have the purpose of causing the death or injury in, say, a reckless manslaughter case. They only need to have the mental state required for that specific crime, which would be recklessness.
So if you encourage reckless behavior, and that behavior leads to death, you could be an accomplice to reckless manslaughter.
Precisely. You need to have acted with the culpability required for the offense itself when you provided the aid or encouragement.
Let's use that driving example to make sure we've got it. Driver A is driving like a maniac, totally reckless. Passenger B is yelling, "Go faster, floor it."
Okay.
And then driver A hits and kills a pedestrian. How does the MPC look at passenger B?
Under the MPC, passenger B could very likely be held liable for reckless manslaughter as an accomplice.
Even though they didn't purposefully want anyone to die?
Correct, because they purposefully encouraged the reckless driving, and recklessness is the mental state required for that type of manslaughter. They aided and encouraged the conduct that caused the death, and they did so with at least the level of culpability, recklessness, needed for the resulting crime.
I see. So if the crime itself is defined by a result, like death or injury, the accomplice is responsible if they help cause that result and they had the mental state required for that result-based crime, intent for intentional murder, recklessness for reckless manslaughter, etc.
You've got it exactly. The MPC links the accomplice's mental state to the specific elements, including the result and the culpability level of the crime committed.
Okay, this has been, wow, a really detailed look at how the law views helping others commit crimes. If we were to sort of boil it down, what are the main takeaways comparing common law and the MPC here?
Well, I think the biggest picture is that both systems agree that you can be responsible for crimes you didn't physically commit yourself. They both punish facilitation.
Right. The core idea is the same.
But how they determine that liability differs. Common law traditionally had a broader net with the natural and foreseeable consequences rule and those distinct categories like accessories.
Yeah, potentially catching more unintended actions.
Whereas the MPC generally requires that stricter purpose regarding the aided crime, it ditches liability for those unforeseen consequences, and it really simplifies the classifications. Everyone's just an accomplice.
So tighter focus under the MPC, generally speaking.
Generally, yes. But the bottom line under either system is that legal responsibility goes beyond just the person pulling the trigger or grabbing the cash. Involvement matters.
It absolutely does. Whether we're talking common law rules developed over centuries or the more structured MPC, the message is clear. Helping, encouraging, even maybe failing to act when you should. It can all have serious legal weight.
It definitely makes you think, doesn't it?
Right.
Consider, situations where people know something wrong is happening, they're aware, but they aren't directly involved. Maybe they just stand by.
Yeah. Where does the ethical line blur with the legal one we've been discussing?
Exactly. What's the difference between just knowing and implicitly encouraging? Or knowing and having a duty to stop it? It's definitely something worth mulling over. We're kicking off today with something that sounds simple, but really isn't. How far can you legally go to protect yourself?
Right.
It's something we kind of feel we know, but the details, they matter.
They really do.
You see it everywhere, right? News, movies, people chatting about what if this happened or what if that happened with self-defense. But what does the law actually allow?
Exactly. So today we're going to dig into a bunch of legal texts, kind of unpack the rules around self-defense.
Okay.
Our goal is really to give you a solid understanding of when using force is actually okay legally. Cut through the myths and get to the facts.
Okay, sounds good. So where should we start? Maybe with situations that aren't necessarily life or death, like non-deadly force.
Yeah, good place to start. So a basic idea here is, generally speaking, you don't have to run away before using non-deadly force. If someone's threatening you, but it's not like going to cause serious injury or death, You can usually stand your ground and defend yourself.
And that comes from the idea that, well, if you haven't done anything wrong, you shouldn't have to be the one to back down, right?
Precisely. The common law thinking is based on that. Someone acting lawfully shouldn't be punished for defending themselves against someone acting unlawfully.
Okay, so what are the specific things that need to be true, for a non-deadly self-defense claim to actually work in court?
Right, there are several key parts. First, you have to actually believe you're in danger. That's subject, it's what you believe.
Okay.
Second, that belief. It also has to be objectively reasonable.
Reasonable meaning?
Meaning, would a sort of typical person in the exact same spot also feel threatened?
So it's not enough to just feel scared. It has to be a justifiable feeling given everything going on.
And here's a really important bit.
Yeah.
The force you use. It has to be against an unlawful threat.
Unlawful.
Yeah. So you can't, punch a police officer who's lawfully arresting you and call it self-defense. The force coming at you has to be illegal or unauthorized.
So, say a bouncer is kicking me out of a club, and he's allowed to do that. I can't claim self-defense if I swing at him.
Correct. That's lawful force he's using.
Yeah.
Also, your fear, it has to be reasonable, not just some vague worry.
Okay, that seems pretty clear.
Now, here's where it gets a little nuanced. The law gets that people mess up under pressure.
Uh-huh.
If you reasonably believe force is necessary, like genuinely thought you had to act, even if it turns out you were wrong about the threat, your actions might still be okay. Justified?
Okay.
But, flip side, if you correctly see that force is needed, but then you go way overboard, use an unreasonable amount of force that's not justified.
So even if you're right about needing to defend yourself, using too much force blows your claim.
Pretty much.
Yeah.
And another thing to remember, if your fear is because you're voluntarily intoxicated.
We're drunk or high.
Right. The law usually says that fear isn't reasonable. Being intoxicated isn't an excuse for misjudging things.
Right, because you chose to impair your own judgment. So how do courts figure out if a fear was reasonable? What do they look at?
Well, they look at the whole situation. The physical stuff, size, strength, of everyone involved. What you knew about the other person, did they have a violent reputation? And also your own past experiences, things that might shape how you see a threat.
It sounds like they really try to get inside your head, but also look at it from the outside.
They do. And the fear has to be real fear, not hypothetical. So for example, say you pull a prank on a friend, you break into their house with an axe, just joking around.
Okay, bad idea.
Terrible idea. And your friend, genuinely terrified, uses deadly force against you. You can't then claim self-defense, even though you didn't mean harm. Your actions caused their reasonable fear.
Wow. Okay, so real fear, reasonable fear against an unlawful act. What about the timing? Does it have to be happening right then and there?
Yes. The harm has to be imminent.
Imminent.
Meaning right now or about to happen immediately. You can't use force as payback for something that happened last week or to stop a threat you think might happen next year. Imminence, that's often a big question for the jury. Was the danger so close, so immediate, there was no other choice? No time to run, no time to call the police.
So I can't attack Bob today because he threatened me last Tuesday.
Correct. And also, the force has to be necessary. Even if harm is imminent, if there's a perfectly safe way to just avoid the whole thing, force isn't justified.
Okay. And then there's the how much part proportionality. Right. You can't go nuclear.
Exactly. You can't use deadly force against non-deadly force. Someone shoves you, you generally can't pull out a gun.
Right.
But if you are facing a threat of death or serious bodily injury, then using deadly force can be justified. The key is proportionality. The force you use should be enough to neutralize the threat you're facing, not more.
Okay. So what if, you're the one who kind of started the whole mess, the aggressor? Can you claim self-defense?
Generally, no. If you're the initial aggressor, and that means more than just, trash talk, actual physical aggression, usually you pretty much lose your right to claim self-defense.
Are there any exceptions, at all?
Yes. There's a limited one. Say you start a fight with non-deadly force, just pushing or shoving, and the other person suddenly escalates things massively, pulls a knife, threatens deadly force.
Okay.
You might regain the right to defend yourself against that specific deadly threat, but only to stop their attack. You can't then chase them down once the immediate danger's over. And the Castle Doctrine, which we'll get to, usually doesn't help initial aggressors either.
Okay, so let's recap the common law on non-deadly force real quick. Usually no duty to run away. You need a real fear, and it has to be reasonable. Fear of unlawful force that's imminent. Force has to be necessary and proportional. And if you started it, you're usually out of luck.
That's a solid summary. Now, this stuff, it gets even more complicated in certain situations. Like, think about domestic abuse cases where a battered woman ends up killing her abuser.
Right, those are incredibly difficult cases. How does the law handle those?
Well, the legal system often talks about confrontational versus non-confrontational homicides.
What's the difference there?
Confrontational is, like, during an act of assault, or right when one's clearly about to start. Those usually fit more neatly into the standard self-defense analysis we just talked about.
Okay.
Non-confrontational is when it happens during a quiet period, a lull. Maybe the abuser is even asleep.
That sounds like a much harder argument for self-defense. The imminent threat part seems tricky there.
It is trickier, absolutely. But courts have recognized that even in those non-confrontational situations, if the woman reasonably believed, based on the history of violence and control, that killing the abuser was the only way to prevent her own imminent death or serious injury, even if not happening that very second, self-defense might still be possible.
So the imminence is viewed through the lens of the ongoing pattern of abuse.
Exactly. The law tries, sometimes imperfectly, to account for that cycle of violence and the constant state of fear it creates.
Okay. Now what if you start a fight, but then you change your mind, you want out?
Right, withdrawal. To regain the right to self-defense after being the aggressor, the law usually requires two things. You have to actually withdraw from the fight, and you have to clearly communicate that withdrawal to the other person.
So just turning and walking away might not be enough? You have to make it obvious you're done fighting?
Yeah, pretty much. Make it clear you're disengaging.
Yeah.
Now, shifting gears a bit, when we talk about using deadly force, the rule on retreat changes somewhat.
How so?
Under common law, generally, if you are facing a deadly threat, someone's trying to kill you or cause serious harm, you usually don't have a duty to retreat before using deadly force yourself. You can stand your ground.
Ah, okay. So that's a key difference. Non-deadly force, no duty to retreat. Deadly force against a deadly threat, also generally no duty to retreat.
Correct, under common law. Now, what about protecting someone else?
Yeah, what if you see someone getting attacked?
If you step in and use force to defend another person, whether you're legally okay hinges on whether your belief that they needed defending was reasonable.
So it's about my reasonable belief, not necessarily whether they were actually in danger.
Mostly, yes.
Yeah.
You don't have to be perfectly right, just reasonable in your assessment of the situation. There is, however, a minority view called the alter ego rule.
Alter ego.
Yeah, it means you basically step into the shoes of the person you're defending.
Mhm.
If they wouldn't have been justified in using force, maybe they were the aggressor originally, then you aren't justified either, no matter how reasonable your belief seemed at the time.
That sounds much riskier for the person trying to help.
It is definitely more restrictive. And one last common law concept, imperfect self-defense.
Imperfect.
Yeah, this applies typically in homicide cases. If you killed someone based on an actual genuine belief that you needed to use deadly force, but that belief was unreasonable.
So you really thought you had to, but a normal person wouldn't have.
Exactly. It doesn't completely excuse the killing, but it can knock the charge down from murder to, say, manslaughter. It recognizes the genuine fear, just not the reasonableness of it.
Okay, so it mitigates the crime because the fear was real, even if mistaken.
Precisely. Now, should we maybe shift over and see how the Model Penal Code, the MPC, handles some of this stuff? It's influential, even if not every state follows it exactly.
Yeah, definitely. What are the big differences with the MPC approach?
Well, one key thing is how it defines reasonableness. The MPC looks at it from the perspective of a person in the actor's situation.
In the actor's situation.
It's a bit more subjective.
A bit more, yeah. It lets the jury consider more of the circumstances surrounding the person acting. But it specifically says you don't include purely personal characteristics, like if someone is just unusually timid or aggressive, in that reasonable person analysis.
Okay, so it tries to find a balance, more context than the purely objective view, but doesn't let individual quirks become an excuse.
Right. And another big difference, under the MPC, imperfect self-defense isn't just for homicide. It can apply to any crime.
If you acted based on a real but unreasonable fear or belief about the need for force, it acts as a partial defense. Your level of guilt might depend on whether your unreasonable belief was reckless or just negligent.
Interesting. What about retreat? Does the MPC agree with the common law about not needing to retreat before deadly force?
No, that's a major difference. The MPC generally requires you to retreat before using deadly force, if you can do so with complete safety.
Ah, so the NPC puts a stronger emphasis on avoiding deadly conflict if possible.
Exactly. There's still an exception. The castle doctrine usually no duty to retreat in your own home, but the general rule is retreat if safe. And even in the home, the force still has to be proportional and usually requires something like attempted forced entry.
Okay, that's a big divergence. What about the initial aggressor stuff under NPC?
It's pretty similar to common law there. If an initial aggressor used only non-deadly force and the victim escalates to deadly force, the initial aggressor can regain the right to self-defense against that deadly force.
Okay, that seems consistent.
Yeah. The MPC also talks about using force when it's immediately necessary, which might be a slightly broader standard than the common law's imminent harm.
How so?
Think about someone waving a gun at you, threatening you, but not yet attacking. Under the MPC, force might be justified then because it's immediately necessary to prevent the threatened harm, even if the attack itself isn't quite imminent in the strictest sense.
So immediately necessary focuses more on the need to act right now to stop a developing threat.
Kinda, yeah. It might allow for slightly earlier defensive action in some cases. But again, the force used must be reasonable and proportional to the threat.
Got it. And just to be clear, the MPC does require retreat before deadly force if it's safe, unless the castle doctrine applies.
Correct. That's a core principle in the MPC approach to deadly force. Protection of others under the MPC is also similar to the common law majority view, based on the actor's reasonable belief about the need to intervene. The restrictive alter ego rule remains a minority position.
So generally, if you reasonably think someone needs help, you can help under the MPC too.
Right. Section 3.04 of the MPC basically sums it up. Using proportional force is lawful if you genuinely believe it's immediately necessary right then to protect yourself against unlawful force.
But the MPC probably also spells out when force is not okay, right?
Oh yeah. It specifies situations where justification fails. Like resisting an arrest you know is being made by a police officer, even if the arrest itself is technically unlawful.
Really? You can't resist an unlawful arrest?
Not with force under the MPC.
Yeah.
The idea is you challenge the arrest later in court, don't escalate on the street.
Well,
Also, generally, you can't use force just to protect property, though there are exceptions.
what are those property exceptions?
Force might be okay if you are a public officer doing your duty, or lawfully helping one, or if you're making a lawful arrest yourself. Or importantly, if you're trying to get back property that was just unlawfully taken from you. Or if using force regarding property is also necessary to protect yourself from death or serious harm.
Okay, so property itself isn't worth fighting over, generally, unless safety or other legal duties are involved.
Exactly. And the MPC is also specific about when deadly force is not justifiable. Big one. If you provoke the whole situation intending to cause death or serious injury, yourself basically, you were the initial deadly aggressor. You generally lose the right to self-defense.
That makes sense.
But there's a twist. Even that initial deadly aggressor might regain the right if they then genuinely believe deadly force is necessary to save themselves from death, serious harm, kidnapping, or forced sexual intercourse. However, even then, they have a duty to try and retreat or surrender if they can do so safely.
Unless they're in their home or workplace, maybe.
Right. The castle doctrine exception applies there too, generally.
Okay.
Unless they were the initial aggressor against a coworker in the workplace, it gets very specific.
Wow, lots of nuances.
Definitely. But the MPC's core idea for self-defense is you assess the necessity based on your belief at that moment, generally without needing to retreat from non-deadly threats, give up property, or stop doing something lawful just because someone else objects violently. And for protecting others, it's justified if you think the third person is threatened, believe they'd be justified in using force, and believe you stepping in is necessary.
Okay, so common law and MPC. Lots in common, but key differences on retreat. Imperfect self-defense, maybe the imminent standard.
That's a good way to put it. Should we move on to duress and necessity? They sound similar, but are distinct offenses.
Yeah, let's do that. These feel like situations where someone is kind of forced to break the law, right?
Like, that's the basic idea. Duress, which is sometimes called coercion, is an excuse for committing a crime because you were forced to by unlawful human threats.
Human threat. So not like a tornado or my dog making me do it.
No, exactly.
Yeah.
Not natural forces, not pets. It has to be another person unlawfully threatening you.
So, the classic example. Someone puts a gun to my head and says, "Rob that bank or I'll shoot you." That could be duress.
That's the classic scenario, yes. Under common law, Several conditions usually have to be met. 1. An unlawful threat. 2. You have to reasonably believe that committing the crime is the only way to avoid imminent death or serious bodily injury.
To yourself or someone else.
It could be to yourself or another person, often limited to family members under common law. And critically, there can't be any reasonable legal alternative. Like, could you have called the police? Unless you reasonably believe they were corrupt or wouldn't help in time, could you have run away? Could you have warned the intended victim?
And the threat has to be the thing that actually makes you commit the crime.
Exactly. It has to cause the criminal act. And here's a huge limitation in common law. Duress is not a defense to intentionally killing an innocent third person.
So you can't choose to sacrifice someone else to save yourself under duress?
Correct. Under common law, that choice isn't excused. Also, the law requires clean hands. You can't claim duress if you, through your own fault or illegal activity, put yourself in the situation where you got threatened.
So if I join a gang and then the gang threatens me to make me commit crimes, I probably can't use duress.
That's often the outcome, yes. Your initial wrongful choice negates the defense. And for prison escapes, claiming duress under common law is tough. Usually requires the inmate to immediately turn themselves in after escaping the threat and prove they couldn't have just reported the threat safely.
Makes sense. How does the MPC handle duress? Is it different?
Yes, the MPC takes a somewhat broader approach. It defines duress as coercion by threat that a person of ordinary firmness in that situation would have been unable to resist.
Person of ordinary firmness. Okay.
And importantly, the threat doesn't have to be of imminent death or serious injury. It can be a threat of unlawful force, potentially including future harm. And the threat isn't limited to just you or your family. It could be directed at anyone.
So a threat against a close friend might count under the MPC where it might not under common law.
Potentially, yes.
Yeah.
The MPC is more flexible there. Also, if you recklessly or negligently got yourself into the situation, you might still be guilty of crimes that only require recklessness or negligence, but maybe not intentional crimes. And unlike common law, the MPC might allow duress as a defense, even to homicide, or to a crime different from the one the coercer demanded.
Wow, so MPC duress could potentially excuse killing someone. That's a massive difference.
This is a significant theoretical difference, yes. And for prison escapes, the MPC is generally seen as more lenient, potentially allowing the defense for escapes prompted by threats of various kinds of unlawful force.
Rare. So duress is about human threats forcing you into crime. What's necessity then?
Necessity is different. It's a justification defense, not an excuse. It means what you did was technically illegal, but it was the right thing to do, the lesser of two evils, because you were facing a choice forced on you by circumstances, often natural physical forces or medical emergencies, not direct human coercion.
So this is less about someone making you do it and more about the situation itself forcing a choice between breaking a law or letting something worse happen.
Precisely. Under common law, again, several elements. There has to be an immediate danger, a situation where choosing not to break the law would result in a significantly greater evil, and that's usually judged from society's perspective, not just yours.
Okay.
The crime you commit must be the most reasonable way to avoid that greater evil. And just like duress, you generally need clean hands. You can't have created the emergency situation yourself through fault.
Can you give some examples where necessity might come up?
Sure. Sometimes argued for things like needle exchange programs, technically breaking drug paraphernalia laws, but necessary to prevent disease spread. Maybe homeless individuals breaking anti-camping laws out of necessity for survival. Sometimes inmates escaping truly dangerous prison conditions like a fire or building collapse.
Okay.
But just like common law duress, necessity is generally not a defense to intentionally killing an innocent person. Choosing one life over another is usually outside this scope.
What about prison escapes under necessity? You mentioned dangerous conditions.
Right. Under common law, it's sometimes allowed if the escape is specifically to avoid a threatened sexual or physical assault that is not happening right that second, but is imminent. Courts look at specific factors. Was the threat specific and immediate? Was there truly no time to complain to authorities? Did the escapee avoid harming anyone else during the escape? And crucially, did they turn themselves in promptly once safe?
Again, sounds like a very high bar to meet.
Extremely high, yes. Now, the MPC view on necessity, also broader than common law.
How so?
For one, it's not limited to natural forces. It can include situations created by human actions too, as long as it's not direct coercion, which would be duress. The danger doesn't have to be strictly imminent, just reasonably believed to be necessary to avoid the harm, and the choice unavoidable.
Interesting.
The MTC text even suggests, controversially, that maybe taking one life to save multiple lives could fall under necessity, although courts haven't really established that.
Wow, yeah, that gets into deep ethical territory. The trolley problem, basically.
Exactly. The general MPC principle is, conduct is justified if you believe it's necessary to avoid a harm or evil, provided the harm you're avoiding is actually greater than the harm caused by breaking the law you broke. And also provided there isn't some other specific defense that applies or clear legislative intent saying necessity can't be used for this crime.
And the clean hands thing still applies, like if you caused the situation.
Yes. If you were reckless or negligent in creating a situation requiring the choice or in assessing the necessity, the defense is generally unavailable for crimes requiring those mental states.
How does the MPC handle necessity for prison escapes, similar to common law?
Pretty similar, yes.
Yeah.
It's potentially available for escaping a threatened sexual or physical assault not currently occurring, and the same factors, specific threat, no time for alternatives, no harm during escape, prompt surrender are considered.
Okay, so wrapping up these three: self-defense, duress, necessity. They all involve difficult circumstances, but the source of the pressure is different.
Exactly. Self-defense is responding to unlawful force directed at you or another. Duress is being forced into crime by unlawful human threats. Necessity is choosing to break a law because circumstances, often non-human, force a choice between that and a greater evil.
And the rules around things like reasonableness, imminence, the duty to retreat, and whether killing is ever allowed, they vary quite a bit between the defenses and between common law and the MPC.
Absolutely. And it's so critical to remember, like you said earlier, these are intensely fact-specific. How they play out in court depends entirely on the unique details of each case and how a judge or jury sees those facts.
Right. It's never black and white.
Almost never. Which leads to a final thought. Imagine a really complex scenario where someone feels threatened, maybe by circumstance and by another person, and they have to act. How would you even begin to untangle whether it's self-defense, duress, or necessity, or maybe none of them? It really shows how tangled these legal ideas can get in real life. Welcome to the Deep Dive. Today we're tackling a fascinating and, let's be honest, sometimes head-scratching area of the law. What happens when property goes missing? And, maybe more complexly, when the person accused might not have been entirely of sound mind.
Exactly.
You're here because you want to get smart on complex subjects quickly and thoroughly, and that's absolutely our aim in this deep dive.
Yeah, we'll be using some pretty detailed legal excerpts here. They cover various property offenses and also the legal frameworks around using insanity as a defense.
Right.
So our mission really is to pull out the crucial bits, give you a clear, structured understanding, maybe even with some surprising angles, hopefully without drowning you in legal jargon.
Okay, sounds good. Let's start with something fundamental in property crimes. Control. It's more than just who bought it, isn't it?
Oh, absolutely. Much more nuanced. The law sees control in a few different ways. You've got ownership, which is the straightforward legal title, having the deed, basically. Then there's possession. That can be actual, like you're physically holding it right now.
Sure.
Or it can be constructive. Think about renting an apartment. You don't own it, but you possess it. You control who comes in and out.
Right, you have the keys.
Exactly. And then there's a third level, custody. This is much more temporary control, like a cashier handling your items at the checkout. They have custody for a moment, but not possession in the legal sense, and certainly not ownership.
Okay. So it's like a ladder of control from temporary handling up to full ownership.
Precisely. A hierarchy of who really gets to decide what happens to the thing.
Now, our sources mention that several different theft crimes, things like larceny, embezzlement, larceny by trick, false pretenses, they've kind of been grouped together under law now. Why is that significant?
Well, it might seem like just legal housekeeping, but consolidating these offenses can actually make a big difference in practice.
How so?
It means prosecutors might not have to prove the exact type of theft occurred. If they can prove the elements of any kind of theft, like larceny, it might be enough for a conviction, even if the specifics look more like, say, embezzlement originally. It simplifies their job, focusing on the core act of stealing rather than fine distinctions.
Okay, interesting. So let's zoom in on plain old larceny then. What really boils down to larceny?
Right. Larceny, at its heart, is taking someone else's lawful possession of personal property without their permission, and, crucially, intending to keep it from them permanently.
Permanently. Okay.
There are 5 key elements you need. First, a wrongful taking you have to actually exercise control over the property. Second, carrying it away, the legal term is asportation, but even moving it a tiny bit counts.
Really? Just a little nudge.
Sometimes, yes. Third, it has to be personal property, not land belonging to another person. Fourth, the taking must be a trespass, meaning without valid consent. And fifth, the big one, the specific intent right then to permanently deprive the owner of it.
So just borrowing something, even sneakily, isn't larceny if you fully intend to return it.
Generally, no. That specific intent to permanently deprive has to be there.
Now, about that intent.
Yeah.
The sources mention something called the doctrine of continuing trespass. That sounds a bit complicated, like legal time bending.
Huh. It sort of is, in a way. It addresses a tricky problem. Proving when the thief formed that intent to keep the item permanently.
Right. How do you prove what someone was thinking?
Exactly. The traditional rule was tough intent had to exist at the exact moment of the taking. But the doctrine of continuing trespass says, look, if you wrongfully take something, maybe just intending to borrow it without asking,
Okay.
that initial wrongful taking, that trespass, is seen as continuing as long as you possess it unlawfully. So if later on, while you still have it, you decide, you know what, I'm keeping this, that later intent can combine with the ongoing trespass to make it larceny.
Wow. So grabbing your coworker's cool pen, planning to return it, but then deciding later it looks better on your desk permanently.
Yeah.
That could become larceny.
That's the idea behind the doctrine, yes. It connects the later intent back to the initial wrongful act.
Okay. Are there limits? What can't be stolen via larceny?
Good question. Larceny applies to personal property. So you can't commit larceny of land itself or things permanently fixed to it, like a built-in oven. Those are fixtures. And it also doesn't typically apply to intangible things, like a business idea or digital data, although other laws cover those.
Gotcha. And there's a defense you mentioned, a good faith mistake, even an unreasonable one. Why allow that?
Because larceny is a specific intent crime. The prosecution absolutely has to prove you had that particular mental state, the intent to permanently deprive.
Right.
So if you genuinely, honestly believed the property was yours, or you thought you had permission, even if that belief was totally unreasonable and mistaken.
Like you thought your identical twin's identical coat was yours.
Something like that, yeah. If the belief is genuine, it negates the specific intent required for larceny. The mistake cancels out the criminal mindset, legally speaking.
Okay, that makes sense. So we've got larceny down. Now, what about larceny by trick? The name itself suggests some deception.
It definitely does. With larceny by trick, the defendant gets possession, remember, just possession, not ownership of someone else's personal property through deception, by making a knowingly false statement about a present or past fact. The victim willingly hands over the item, but only because they've been lied to.
So they're tricked into giving it up temporarily.
Exactly. And like regular larceny, this applies to personal property, not land or services.
Okay. But the sources drew a line, saying a false promise about the future usually isn't enough for larceny by trick. Why not?
Traditionally, the law distinguished between lying about something that is true now or was true before versus just making a promise about what you will do. A broken promise was seen more as a civil matter, like breach of contract, not necessarily criminal theft by trickery.
But there's a twist, right? A modern exception.
Yes, and it's quite subtle. Courts now often say, okay, maybe the promise itself is about the future, but if the prosecution can prove that at the moment the defendant made the promise, they were lying about their present intention to keep it.
Lying about their current state of mind.
Precisely. If they never intended to follow through at the time they promised, that lie about their present intent can be enough for larceny by trick.
That Dylan and Jake Cadillac example really clarifies this. Can you walk through that again?
Sure. Dylan asks Jake to borrow his fancy Cadillac. Dylan promises, I'll bring it back tonight. But secretly, Dylan has zero intention of returning it. The plan is to drive it across the country.
No.
Under the old rule, maybe not larceny by trick, it's a promise about future action, returning the car. But under the modern view, the prosecution could argue Dylan lied about her present intent when she made the promise. That misrepresentation of her current state of mind, I intend to return it when she didn't, is the trick that gets her possession.
Got it. The lie isn't the promise itself, but the hidden intention behind the promise at that exact moment. Okay. Let's shift gears slightly to embezzlement. How's that different?
Embezzlement starts differently. The person already has lawful possession of the property.
Ah, so they didn't snatch it initially.
Right. They were entrusted with it. Think of a company treasurer who has legal control over company funds. Embezzlement happens when that person then fraudulently converts the property for their own use. They treat it as their own, violating the trust placed in them.
So it's about abusing lawful possession.
Exactly. It requires 1, conversion of the property. 2, that property belongs to another. 3, the defendant was in lawful possession, more than just custody. And 4, the intent to defraud, to deprive the owner.
Okay, lawful possession gone bad, and then there's false pretenses, another flavor of deception.
Yes, but with a critical difference from larceny by trick. In false pretenses, the victim isn't just tricked into giving up possession.
They give up ownership.
Bingo. They're deceived into passing the actual title to the property. It also requires a knowingly false representation of a present or past fact.
And like larceny by trick, a false promise about the future generally doesn't cut it here either.
Correct. For false pretenses, a false promise about what you'll do later is definitely not enough. It has to be a lie about an existing or past fact that induces the victim to hand over ownership.
The car dealership example illustrated this well, I thought, with the pink slip.
Yeah, that's a good one. If you go to a dealer and say, give me the pink slip, the title document for that Ferrari, I wired the money yesterday, and that's a lie.
Knowing the wire transfer never happened.
Right. That's a false statement about a past fact designed to get ownership, the title. That could be false pretenses. But if you say, give me the pink slip, I promise I'll bring a certified check tomorrow, and you never intend to.
That's just a broken promise about the future.
Exactly. It might be other kinds of fraud, maybe breach of contract, but not the specific crime of false pretenses. The key is tricking someone into giving up title based on a lie about the present or past.
That difference between getting the keys versus getting the title deed is crucial. Okay, briefly, what about forgery and bad checks? How do they fit in?
They're related forms of fraud, often involving property. Forgery is making or altering some kind of writing that has legal significance, like a check, a contract, a deed with the intent to defraud someone.
Changing the amount on a check, maybe?
Perfect example. Or forging a signature.
Yeah.
Writing bad checks is more specific. It involves, 1, writing a check knowing you don't have enough funds to cover it, and 2, doing so with the intent to defraud, meaning you're trying to trick the recipient into accepting it as real payment.
So it's not just bouncing a check by accident.
No, the intent to defraud is key. Our sources note that simply having bad accounting skills, if you genuinely didn't realize the funds weren't there or didn't intend to cheat anyone, could potentially be a defense. It negates the required criminal intent.
Right, I got to prove they meant to rip someone off.
Yeah.
Now, the Model Penal Code, the MPC, tries to simplify all this theft stuff, right? How does it work?
Yeah, the MTC aims for simplification. It largely lumps larceny, embezzlement, false pretenses, and similar crimes under one big category: theft.
Just theft.
Pretty much. And then it grades the seriousness, usually based on the value of what was stolen.
Makes sense.
So generally, it's a felony third-degree theft if the value is over a certain amount, say $500, or if it involves specific things like cars, firearms, boats, or if the thief is basically fencing stolen goods.
And if it's less?
Then it's usually a misdemeanor. Although, if it's a really small amount, like under $50, and it didn't involve threats or taking it right off someone's person or abusing a trust, it might even be just a petty misdemeanor.
So value is key. But how you steal still matters a bit for the really minor stuff.
Exactly. And if you steal multiple items as part of one scheme, they usually add up the total value to determine the grade.
Okay. Does the MPC offer any specific defenses, situations where taking something isn't theft?
It does. It lays out some affirmative defenses, like if you honestly didn't know the property belonged to someone else, or if you had an honest, even if mistaken belief, you had a right to take it, a claim of right.
Similar to the larceny mistake defense.
Yes. Or, interestingly, if you take property that's clearly for sale, intending to pay for it promptly, and reasonably believing the owner would consent, like maybe taking a newspaper from a stand intending to pay later when the owner arrives.
Practical. What about theft between spouses? That seems like a tricky area.
Very tricky. The MPC generally says being married to the victim isn't a defense to theft. You can steal from your spouse.
Okay.
However, there's a specific exception for misappropriating household goods, personal effects, or other property that both spouses normally have access to. In that specific context, it only becomes theft if the taking happens after the couple has separated and stopped living together.
Ah, so it acknowledges the shared nature of things during the marriage.
Right. It reflects the reality of shared lives and property before a formal separation.
Okay, let's move up the seriousness scale to robbery. The sources called it larceny by assault. That sounds much more forceful.
It absolutely is. Robbery is a major step up, usually a felony, and it's a general intent crime. Common law defines it as taking personal property from someone's person or their immediate presence.
What counts as presence?
It means close proximity and control, so not just from their pocket, but maybe a bag sitting right next to them on a bench, close enough that they could have prevented the taking if not for the violence or threat.
Okay.
And that's the key difference. The taking must be accomplished by force enough to overcome resistance or intimidation, putting the victim in fear of immediate bodily harm. Plus, you still need the intent to permanently deprive.
So it's larceny plus violence or the threat of it.
That's the core of it. Without the force or fear, it's larceny. And many places also criminalize attempted robbery.
Are there worse versions of robbery?
Yes, aggravated robbery, that usually involves things like using a deadly weapon, causing serious injury, or having an accomplice present.
Got it. Okay, last property crime on our list. Burglary. What defines that? It's not just breaking in, is it?
No, common law burglary is very specific. It requires, 1, a breaking. This doesn't have to be smashing something, opening a closed window, or door counts. Even getting in by trickery, constructive breaking, can qualify.
Like pretending to be a delivery person.
Exactly. 2, an entering. Any part of the body crossing the threshold, or even just a tool used for the crime going inside, counts. 3, it has to be a dwelling where someone lives. 4, it has to be at night.
Wow, really specific.
Very. And 5, the crucial mental element. At the time of breaking and entering, you must have the intent to commit a felony or larceny inside.
So you have to plan the next crime before you even go in.
Yes. If you break in just to get out of the rain and only then decide to steal something, that's not common law burglary because the intent wasn't there at the moment of entry. It might be trespass and larceny, but not burglary.
And the crime you intend to commit inside can't just be trespassing, right?
Correct. It has to be a separate felony, like assault, rape, arson, or larceny. Trespassing is inherent in the breaking and entering. It can't be the underlying intended crime for burglary itself.
Okay, a very particular set of elements. Right. Let's switch gears completely now. Let's talk about the insanity defense. This comes up a lot in movies, but what's the real legal deal?
It's a really complex area. The insanity defense is fundamentally an excuse. It argues that even if the person committed the physical act, they shouldn't be held criminally responsible because of their mental state at the time of the crime.
Now, if their current state.
No, that's competency. We need to distinguish those. But first, the procedural side of insanity is important. Who has to prove it? In most states, the defendant has to prove they were insane, usually by a preponderance of the evidence, basically, more likely than not.
Okay.
But in a minority of places, the prosecution has to prove the defendant was sane beyond a reasonable doubt, and federal courts often use a standard called clear and convincing evidence for the defendant to prove insanity, so it varies.
Right. And you mentioned the crucial difference between competency and insanity. People mix those up all the time.
They really do. Competency is about the defendant's mental state now, at the time of the trial. Can they understand the charges? Can they assist their lawyer in their defense?
If they can't, what happens?
If found incompetent, the trial stops. It's paused until they regain competency, maybe through treatment. Incompetency doesn't excuse the crime, it just delays the legal process.
But insanity looks back in time.
Exactly. Insanity focuses on the defendant's mental state when the crime occurred. If the defense is successful, it can lead to an acquittal not guilty by reason of insanity, though that often means commitment to a psychiatric facility, not walking free.
Okay. The sources also talk about disease versus defect of the mind. What's the difference legally?
Generally, a mental disease is seen as something potentially curable or manageable, maybe like severe depression or schizophrenia that responds to treatment. A defect is usually considered a more permanent, perhaps developmental condition like an intellectual disability.
Does the law exclude any conditions?
Yes, and this is a really important point. Most legal tests specifically exclude conditions where the main symptom is just repeated criminal or antisocial behavior.
Like psychopathy or sociopathy?
Exactly. The law generally says just having an antisocial personality, a tendency towards crime, isn't itself a basis for an insanity defense. The defense requires an underlying disease or defect that significantly impacts cognitive ability or control, not just a predisposition to bad acts.
That seems like a critical distinction the law tries to make.
Okay.
Okay, let's dig into the tests courts actually use. The big one seems to be the Knighton rule.
Knighton is definitely the most common test, the majority rule in the U.S. It's fundamentally a cognitive test. It asks, did the defendant, because of a mental disease or defect, understand the nature and quality of the act they were doing?
Like, did they know they were firing a gun?
Yes, that kind of basic understanding. Or, if they did understand the physical act, did they know that the act was wrong?
Wrong according to whom? Themselves or society?
Generally wrong, according to societal standards. Could they appreciate that what they were doing violated the law and accepted moral codes? Knighton focuses almost entirely on knowing and understanding.
The John example with the paranoid delusions about his neighbor helps here. Could you run through that again?
Sure. John has severe paranoid schizophrenia. He attacks his neighbor because he genuinely, delusionally believes the neighbor is an enemy agent about to harm him.
Okay.
Under McKnighton, you ask, did John understand the nature and quality of his act? Maybe not. He thought it was self-defense, not an assault. Or did he know the act was wrong? Again, maybe not in his delusional state. He believed it was necessary and justified. If the jury believes his mental illness prevented either understanding, he could be found not guilty by reason of insanity under McKnighton.
And the sources mentioned a divot command, God telling someone to do something.
Yes, that can sometimes be considered under the knowing it was wrong part. If someone truly believes they are acting under a direct command from God, that delusion might prevent them from appreciating that the act is considered wrong by society. It's evidence potentially supporting an insanity claim under McKnighton.
So McKnighton is all about knowing and understanding. What about the minority tests? Do they look at something different?
They do. They often add a volitional component looking at self-control. The irresistible impulse test is one.
Irresistible impulse.
Yeah. It asks if the defendant, due to mental illness, lacked the capacity for self-control and free choice. Could they stop themselves? Even if they knew the act was wrong, unlike Knighton, were they simply unable to refrain from doing it because the mental illness compelled them?
So it adds a control element Knighton lacks.
Exactly. Another minority test, though less common now, is the Durham test, or the product test. It basically asks, was the unlawful act the product of mental disease or defect? Would the crime have happened but for the illness? This is quite broad and has been criticized for being hard to apply.
Okay, so different angles. Knowing versus controlling versus being a product of illness. How does the Model Penal Code, MPC test, fit in?
The MPC tries to bridge the gap, incorporating both cognitive and volitional aspects. It uses the phrase, lacks substantial capacity.
Substantial capacity, not total inability.
Right. The defendant isn't responsible if, due to mental disease or defect, they lacked substantial capacity either to appreciate the criminality or wrongfulness of their conduct.
So understanding, similar to Knighton, but maybe a deeper appreciation.
Yes, appreciate suggests a deeper understanding than just know. Or lacks substantial capacity to conform their conduct to the requirements of law.
Ah, there's the control element, like irresistible impulse.
Exactly, it combines both. Did they lack substantial capacity to understand it was wrong, or did they lack substantial capacity to stop themselves? But like the other tests, the MPC explicitly excludes conditions that only manifest as repeated criminal or antisocial acts. No insanity defense just for being a habitual offender.
The MPC also brings up diminished capacity. Is that the same as insanity?
No, it's related, but different. Diminished capacity isn't a full defense leading to acquittal. It argues that while the defendant might not meet the full insanity standard, their mental disease or defect did prevent them from forming the specific mental state required for a particular crime.
Like the specific intent for murder.
Precisely. Evidence of diminished capacity might show they couldn't form the intent needed for first-degree murder, potentially leading to a conviction for a lesser offense, like manslaughter. It's about partial responsibility. The MPC says evidence of mental issues is generally admissible whenever it's relevant to the defendant's state of mind for any element of the crime.
Okay. And the Sarah example with schizophrenia and arson illustrates the MPC insanity test.
Yes. Sarah has schizophrenia, experiences powerful delusions, and sets fire to her neighbor's house believing it contains government surveillance equipment spying on her.
Okay, a clear delusion.
Under the MPC test, you'd ask, did she lack substantial capacity to appreciate the wrongfulness? Maybe. Her delusion made her think it was a necessary act of self-defense. Or did she lack substantial capacity to conform her conduct to the law? Perhaps her illness and delusions were so overwhelming she couldn't control the impulse to act on them. If either is met due to her schizophrenia, she could be found not guilty by reason of insanity under the MPC.
And the source connected lack of empathy to appreciating wrongfulness.
Yeah, an interesting point. It suggests that a profound inability to feel empathy, perhaps stemming from a mental condition, might impact someone's substantial capacity to truly appreciate the harmfulness and wrongfulness of their actions towards others.
So the MPC seemed like a more nuanced approach, blending understanding and control. Wow, we've covered a lot of ground here. From the nitty-gritty of property crimes.
Yeah, defining control, possession, title, distinguishing larceny from embezzlement, from false pretenses.
All the way to the really deep, complex legal tests for insanity. Not irresistible impulse, MPC.
We've really seen how the law tries, sometimes clumsily, sometimes quite elegantly, to define these concepts. Control over things, control over oneself, essentially. And how intent, that mental state, is just so critical in almost all of these areas.
It is striking, isn't it? How the legal system builds these detailed frameworks to grapple with intent, with mental states, trying to apply rules to the complexities of human behavior and mental health.
Absolutely. This deep dive, I think, shows that ongoing effort to balance clear rules with the messy realities of property disputes, and even more so the human mind when it's affected by illness. It's about finding frameworks that aim for justice but also acknowledge these deep complexities.
So thinking about all these different insanity tests, we discussed the cognitive focus of Mnatin, the control aspect of irresistible impulse, the combined approach of the MPC. It really makes you consider, what are the inherent difficulties, the real challenges, in deciding criminal responsibility when mental illness is involved? How do these different legal rules, with their different focuses, try to walk that tightrope between justice for victims, accountability for actions, compassion for the mentally ill, and of course, keeping the public safe? It's certainly something to think about. Thanks for joining us for this deep dive.